Good morning, everyone in the room and online. Welcome. Convocation is now webcast regularly as part of our commitment to outreach and transparency in governance. I would like to review the instructions for the phone system for those participating by phone. I'm going to go through the list of people who we expect are on the telephone, get any other new attendees, and then let everyone know that we will be placing those calling into the meeting in what we call lecture mode. And that means from our end, we are muting other callers. Once muted, they'll be able to hear the meeting but cannot speak. So it's *6 from our end for everyone. We, of course, will need to come out of lecture mode to hear callers who wish to speak and vote, and we'll do that following presentations of reports and motions. At that time, unless callers wish to speak, we ask you to *6 their telephones as we've done in the past, or as they have done in the past. We'll repeat this throughout convocation as necessary if there are problems with the phone. So let us go to the list now. I have a list of people who've indicated they would be on the phone. I'll call that out first. Larry Bannock.
Present.
Giselle Chrétien.
Yes, I'm here.
Teresa Donnelly.
Present.
Patrick Furlong. Janet Leeper.
Present.
Thank you. Jeffrey Lem.
Present.
Gavin McKenzie. Heather Ross.
Present.
Clayton Ruby. And Harvey Strasberg.
I'm here.
Thank
Hi,
you.
Kathy.
Hi there. Okay, is there anyone else on the phone?
Roger Yuketti.
Okay, Roger, you
Judith
can.
Potter.
Jonathan Rosenthal. Brad Wright.
Just a minute. Okay,
Gavin McKenzie.
I called your name, Gavin. Okay, Mr. McKenzie, I should say. That's good. Okay, so we have added Mr. Yuketti, Ms. Potter, Mr. Rosenthal, and Mr. Wright.
And Ron May.
And Mr. Baines. Okay, thank you. All right, thank you very much. And now, over to Mr. Lerner. Okay.
The conference is in lecture mode.
*6. I'd like to welcome a number of guests we have in attendance today. Jeffrey Hirsch, who is here, who recently took office as president of the Federation of Law Societies. He's been a member of the Federation Council for the Law Society of Manitoba since 2009, and he will be our guest at lunch today. We also have representatives from the Law Foundation of Ontario, Tanya Lee, who's Chief Executive Officer, Judy Mark, Chief Financial Officer, and Kirsty Mathers McHenry is the Director of Policy and Programs. And finally, see her, Dr. Patricia Hughes, Executive Director of the Law Commission, and Anna Nye Thomas, Executive Director Designate. So we'll be hearing from them a bit later in the proceedings. November has been quite a busy month for me. I've attended a number of events, conferences, etc. And excuse me, we have been putting a list of some of my activities on board books, which is accessible to benchers. However, it's not accessible to members of the profession and public. So I'm now going to have a list of activities attached to my report to Convocation so that it will be available to the profession and public. Nonetheless, I'd like to highlight a few of the events. And one of the most memorable was my visit to Nunavut in early November. Tom Conway was invited to attend as well as president of the Federation of Law Societies. We had the opportunity to meet with members of council of that law society, along with a number of government lawyers, the Minister of Health and Justice, Paul O'Kellick, and the Deputy Minister, Elizabeth Sanderson, and Assistant Deputy Minister, Yvonne Niego. And we had an opportunity to understand particular access to justice issues and other regulatory issues faced by the Law Society of Nunavut and their profession and the justice system, frankly. And we discussed ways that we might be able to assist them in addressing many of these issues. We also learned, of course, some interesting areas in which they're working, which may benefit us. Along with me were two members of our staff from the Spot Audit Department, Henny Harmson and Rimpal Hinduja, who were visiting there to assist in providing CLE to the members of the Nunavut Society and also engage in discussions relating to training with the Law Society of Nunavut. I'd like to particularly thank their president, Scott Whalen, and CEO, Nalini Valdapalli, who I think outdid themselves in assisting us and showing us hospitality. It was an extremely interesting and beneficial trip, and again, I'm very grateful to have been able to attend. I look forward to further collaboration with them in the future in whatever way we can assist through staff or otherwise. There were also a number of other conferences that I, along with other benchers and staff, have attended. The County and District Law President's Annual Fall Conference was held in Toronto. One item of business that came out of their fall meeting was a name change, and so they've officially changed their name to the Federation of Ontario Law Associations, FOLA. I also attended the Advocate Society Fall Conference, the County of Carleton Law Association Annual Civil Litigation Conference, as well as the Association of Law Officers of the Crown. Unfortunately, that conference conflicted with our Louis Riel event, and I was not able to attend that, but Julian Faulkner and other benchers were in attendance. I understand it was a great success. At all of these events, I review our major initiatives and try to address issues of particular concern to the group to whom I'm speaking. As I always do, I update on the status of our challenges for racialized licensees and our access to justice initiatives. However, I also decided to make a point of including in my remarks something that is very important to me as treasurer, and that is access to justice issues facing First Nation, Métis, and Inuit communities. And as you know, I've made it a priority to engage directly with First Nation, Métis, and Inuit leaders and citizens to build a better understanding of the access to justice barriers they face. I think it's important that our other stakeholders hear about our initiatives in this respect, so I use every opportunity I can to speak to them. I raise some of the history of these issues, including the Truth and Reconciliation report, and comment on the need for reconciliation, not just from institutional and community perspectives, but also on a personal basis. And I have found that all the groups to whom I have spoken have been extremely responsive and interested in our initiatives in that respect. Last week, Sheena Weir and I took a road trip through the East region. And this was another highlight. Our first stop was Lanark County, where we attended a local law association event. We then traveled to Kingston, where we hosted a regional dinner meeting with all the presidents and representatives of local law associations in the East region. And finally, we were invited to attend, and we did attend a dinner hosted by the Renfrew County Law Association. That dinner honored Stuart Lavigueur, who you will recall received a Law Society medal last year. He was described as the only lawyer in Eganville and the quintessential country lawyer. The Law Association determined that he is the only person from Renfrew County who has ever received a Law Society medal, so they honored him with a dinner, and it was very well attended. It was quite clear that he is a local hero and highly respected by the profession and the community. And on that note, a reminder that nominations for the Law Society Awards are now open. The deadline is January 29th, 2016, And I would ask people to remember that we can't give awards without applications for them. In April, we approved the establishment of a new award in honor of former Treasurer John Shirley Dennison to be bestowed annually in recognition of significant contributions to access to justice and/or poverty issues. Both paralegal and lawyer licensees of the Law Society are eligible for this award, and it is established to honor Dennison's commitment to helping others. And to remind you, the other awards are the Law Society Medals, the William J. Simpson Distinguished Paralegal Award, the Laura Legg Award, and the Lincoln Alexander Award. Information on the nomination process is on the Law Society website. I'd like to encourage nominations from all communities and practice areas, firm sizes, and regions across the province. I'll be contacting local associations and other stakeholders to ensure that they're aware of the awards and the nomination process, but I would also encourage benchers to reach out to your own contacts to encourage others to think about who in their community has made a difference. There are a great number of our professions who are very giving of their time and have contributed a lot to the profession and the administration of justice. Again, to remind you, without nominations, we can't give awards. And speaking of awards, one of our benchers, Isfahan Morali, was recognized, I think just this week, by the South Asian Bar Association at their gala, and she was one of the recipients of the Saba Legal Excellence Award, which celebrates leadership, excellence, and diversity demonstrated by members of the Ontario legal profession. So, congratulations, Isfahan. On November 23rd, I was pleased to bring greetings and also thank the Attorney General for her remarks at the inaugural Family Dispute Resolution Institute of Ontario Conference, known as FIDRIO. This event kicked off Family Dispute Resolution Week. It was wonderful to support the collaborative efforts of family law professionals who are committed to ensuring that Ontario families can manage their disputes in a reliable, safe, and effective manner. I should add that family law professionals refers to more than lawyers. There are other professionals involved in that conference and organization. The Law Society hosted many FDR Week sessions, some of which shed light on the experiences of self-represented litigants and explored the strong evidence on access to justice challenges. These sessions showcased the variety of services available across the province and emphasized how they are often not widely known. The work of TAG, the Action Group on Access to Justice, was noted in these sessions and received strong positive feedback. I was also invited to participate in the Justice Roundtable that Attorney General Mayer hosted on November 27th. Many others participated as well, including representatives of the courts, legal associations, Legal Aid Ontario, and other justice partners. Presentations were made by the Family and Criminal Justice Tables. The Family Justice Table is considering the need for triage at the early stages of the court process to address needs of litigants before and during the court process. The Criminal Justice Table is focusing on improvements to access to justice for mentally ill accused persons. The discussions were very productive. And the Minister expects options for pilot projects will come forward in the new year. We look forward to continuing this important dialogue. I've written to the Honourable Jody Wilson-Raybould to congratulate her on her appointment as Minister of Justice and Attorney General of Canada. I've extended our best wishes and our desire to collaborate in achieving movement on the many important objectives we share. Prime Minister Trudeau, to whom I also wrote, released publicly his mandate letters for each minister. These are excellent and transparent sources of information on the federal government priorities. From reconciliation to access to justice to criminal code modernization, we will have much on which to collaborate. Seeing a strong commitment to a unified family court was also most welcome. All of these cabinet mandate letters are publicly available on the website and of great interest. I would commend their reading to you. As benchers will recall, one of our strategic priorities is governance improvements, and a specific initiative identified by benchers was developing an education plan for board professional development. We are working on developing that plan, and the current proposal is to schedule a meeting of benchers as a committee of the whole at the start of convocation for up to an hour, beginning in the new year. As many of you know, board education is regarded as a best practice and regularly followed by other boards. We are looking at a program which might relate to benchers' responsibilities as members of convocation and enhance their governance and leadership skills, knowledge of the Law Society, and the environment in which it governs. As I said, while I've identified a number of topics and a number of suggestions have been made to me from benchers, we are inviting everyone to make suggestions. Mr. Vero will be emailing you this month requesting suggested topics for your board CPD, so I urge you to respond to that. 2 upcoming events in our public education series are on January 26th, which is International Day of the Endangered Lawyer Rule of Law event, and January 27th, Lawyers Feed the Hungry Bencher Volunteer Day. And I'd like to turn to our consent agenda first, and then following that we will have our addresses by various guests. So on the agenda we have a consent agenda. And before we turn to it, I would just mention that one item on it, which is the motion for appointments, relates to our library co-appointments, and these are for renewal of the current members of Library Co. who were appointed by convocation. Library Co. is in the midst of a significant transition plan for the development of the future of the library system in Ontario. And in my view, it's important to maintain the continuity of those members on that board. Are there, and that is a motion brought by Carol Hartman and seconded by Diane Corbière for the consent agenda to be passed. Is there any comment or request to remove anything from the consent agenda? Okay, if not, the motion is moved. All in favor? Okay.
The conference is no longer in lecture mode.
Any opposition on the phone? If not, the motion is passed. Thank
The
you.
conference is in lecture mode.
I'd like to just introduce briefly again Jeff Hirsch, who's the president of the Federation of Law Societies of Canada. He will be, I will say a little more about him at lunch, but I wanted to give him the opportunity this morning to bring greetings. He will be addressing convocation in a more formal way next year.
Thank you, Treasurer. I'm delighted to be here at Convocation. Thank you so much for inviting me. I'm
Webcast.
Webcast.
Mr. President.
Hi, Webcast. I was comfortable speaking to you in the corner where you couldn't see me, but I'm glad to get the podium. As I said, I'm delighted to be with you here at Convocation. This is my first Law Society Benchers meeting as president, and of course my first convocation, so I'm thrilled to be here. I'll be coming back to visit with you and to hear from you and to speak to you in the new year, but for today I'm just bringing greetings from the Federation. I look forward to speaking with you and spending the first half of the day with you. So thank you very much.
Thank you, Mr. Hirsch. Okay, Mr. Shabas.
Good morning, everybody. Thank you, Treasurer. I am pleased to address you for a few minutes in my capacity as Chair of the Law Foundation of Ontario. And you will find our annual report at tab 1 of board books, our 2014 report. As the treasurer has indicated, we're joined by the senior staff of the Law Foundation today. Tanya Lee, the CEO, Judy Mark, the Chief Financial Officer, and Kirsty Mathers-McHenry, our Director of Policy and Programs. It's a great opportunity for us at the Law Foundation to speak to you. We are keen to raise our profile. We're keen to boast about the achievements of the Law Foundation of Ontario, and I'm particularly pleased today to be speaking to many people who I can still at least call newish benchers, who may not be as familiar with the Law Foundation or may in fact be quite unfamiliar with the Law Foundation, which was created over 40 years ago under the Law Society Act as an organization, a grant-making organization charged with the authority to collect interest on lawyers' mixed trust accounts and then to dispense that money in accordance with certain provisions in the statute, but to be directed towards the ends of supporting legal aid, legal research, law libraries, and legal education, which we generally describe as access to justice. The Law Foundation is governed by a board of trustees, 3 of whom are appointed by Convocation, 2 of whom are appointed by the Attorney General. The current trustees, first of all appointed by the Attorney General, are Stephen Rhodes, who is the Deputy Minister of Corrections, if I've got that right. Used to be the Solicitor General, but I'm just showing my age when I say that. And Chris Clifford, who is a personal injury lawyer in Kingston, Ontario. The 3 Law Society appointees are Ross Earnshaw, Linda Rothstein, former bencher, and myself. The idea of Law Foundations actually came from Australia to Canada over 40 years ago, and it was then copied by just about every state in the United States. They call them IOLTA organizations. IOLTA means Interest on Lawyers' Trust Accounts. I don't know why they haven't thought of a better name, but we have. We get our revenue, as I said, from the Interest on Lawyers' Trust Accounts, and also more recently, and I'll come back to this in a minute, from Cypre awards from class actions. By statute, 75% of our funds goes to Legal Aid Ontario, net of our expenses. And the rest we get to distribute in accordance with our statutory objects. Over the past 41 years, we have collected and dispensed almost $1 billion in funds. In 2007, the year I joined the board, we had revenue from interest of $77 million. By 2009, no doubt due in part to my contribution, the revenue had dropped to $13 million, which created a massive problem for us. It was a real crisis. It was a problem for legal aid, which had grown used to receiving more money. But we all know what happened between 2007 and 2009. I'm pleased to say that over the last couple of years now, we have recovered revenues that are now in the $30+ million a year range. I think last year was about $37 million. We have achieved that not through increases in interest rates, though they did go up a little bit, though when I became chair last January they dropped again, another sign. But through better tracking of funds, better work and hard work negotiating with the banks, and we're thankful to Judy Mark's very professional leadership in that area. And interestingly as well, higher trust balances. There is well over $3 billion in lawyers' mixed trust accounts daily in this province. That's quite a bit more than it was a few years ago. We don't fully understand why that is. Hopefully it reflects economic activity. It might also reflect the fact that interest rates are so low, people just don't mind it sitting there doing nothing, which suits us because we get our little bit of it. But as a result of prudent planning, reserve funds, and so on, we've been able to largely hold the line on our grant making. Last year, as our annual report shows, we gave out about $8.5 million in grants. That's after the funds that were sent to legal aid. And We do that as an active funder. We, for many years, were an organization that was a responsive funder, received applications, sounded like a good idea, we had the money, we gave it out. We give a lot of money to the law schools. For many years, it just went into their revenue and they did with it what they wished. But I would say over the past decade or perhaps a little more, the Law Foundation has become much more of a professional foundation of being an active and supportive funder, as a funder that seeks out innovative ideas and calls for a great deal of accountability from its grantees. And just by way of example, to go back to the law schools, we worked hard with them to persuade them that the funds we gave them had to be directed towards access to justice issues, such as supporting legal clinics and supporting experiential learning involving law students. And they've accepted that, and we work together with them and with the students in promoting access to justice within the schools. We've also created organizations. The Law Foundation was instrumental in the creation of Pro Bono Law Ontario, which in the first 6 months of this year alone served over 10,000 people. We created, in partnership with the Law Society and others, I don't mean to say we created PBLO all by ourselves either, but we also created OGEN, the Ontario Justice Education Network, which works with students in high schools and educating people about the law. So let me touch on a few specific areas as well that I think would be of interest to you. This past year, as our annual report shows, we provided a grant to this organization, the Law Society, to support TAG in the amount of $400,000. The action group is working on collaborative solutions, as we know, to access to justice challenges. We're pleased to be a partner in that and to provide support for that. We provide grants, in addition to law schools, to community colleges, to community college libraries to support paralegal education. We fund 13 articling positions at community legal clinics and public interest organizations to support students who work in a range of areas from international human rights to domestic violence, environmental law, and consumer rights. We have a number of organizations, and I mentioned a couple of them already, who are what we would call our long-term grantees. And the list is, I believe, very impressive. It includes the Association in Defense of the Wrongly Convicted, the Canadian Civil Liberties Education Trust, which goes into the schools across the province with very innovative and dramatic legal education, explaining to students legal rights. Community Legal Education Ontario, or CLEO, is one of our largest grantees that supports public legal education, including the website Your Legal Rights. The Law Commission of Ontario, which you're going to hear from, we are a partner in supporting that organization over the past 6 years? 8 years, sorry. 8 years. Seems like yesterday, Patricia. Other organizations include METRAC, which is a violence against women organization that provides legal education to victims of violence. OGEN I've mentioned, PBLO I've mentioned. Pro Bono Students Canada, which supports the provision of pro bono civil legal services in every law school in Canada. And the Osgood Society for Legal History. One of our more recent creations has been something we call the Connecting Project, which we operate through the South Ottawa Community Legal Clinic and CLEO to find ways to connect organizations and enhance legal services to people in remote communities and with linguistic challenges. And they're partnering with over 50 legal agencies and community organizations to connect people to legal services and to other social services. In particular, that involves interaction with settlement workers, who I know will be very busy over the next few months as we bring in many people from Syria. So we also are a responsive grantor. We still take applications, though we've had to tighten our belt. We earmark $1 million a year to grant money to people who apply to us with innovative projects. And Has included, for example, projects to assist linguistic minorities, people who've experienced domestic violence, and self-represented litigants. The Law Foundation also provides administrative support and assistance to the Class Proceedings Committee, another organization many of you will have heard of but may not be that familiar with, which provides support to approved class actions, to the plaintiff side of class actions. And they report to us, and their report is included in our annual report. The Class Proceedings Fund has support from the Law Foundation and support from our fellow bencher Gina Papageorgia, who's here today, who is counsel to the Class Proceedings Fund. Gina calls us trustees when there's bad news because the quid pro quo of funding a class action is that if the class action is unsuccessful, the Class Proceedings Fund must pay the costs. And she has to take instructions from the foundation when there's bad news. But I'm pleased to say, again, through very good management, a fund which started over 20 years ago with just $500,000 now has over $20 million in its bank account to support access to justice through class proceedings. Related to class proceedings is a new initiative which started a number of years ago with the great support of Harvey Strasberg, when the Law Foundation received a Cypre Award from the Cassano case of approximately $14 million. This is money left over from settlements of class actions or judgments in class actions. And it was directed to be administered by the Law Foundation in furtherance of our objects, which are to support access to justice. And we created something called the Access to Justice Fund. We hired Tanya Lee at the time to figure out how to deal with that money. And in effect, we went national because many class actions are national. The plaintiff's class was national. And we then began to work with law foundations across the country to develop criteria and priorities in grant making. And one of those priorities was to support Aboriginal organizations and to support the expansion of services, legal services to the Aboriginal communities across the country. We've used up that money. We gave out over 100 grants, but we've received a lot more. And I'm pleased to say that we now have approximately $8 million, again, in that Access to Justice Fund. And our new Director of Policy and Programs, Kirsty McHenry, is developing calls for applications, and we hope to see some very innovative applications in that area. We're grateful to the Class Action Bar. We're grateful to the continued support of Mr. Strasberg and others who are trusting us to do good things with those Cypre funds in the public interest. We've recently completed working with the Law Society in revamping the Form 1 in the annual return so that there, I think, as I understand it, there will no longer be a Form 1. It'll just be one form, which will ensure that we capture hopefully 100% of the interest in lawyers' trust accounts. We, for a variety of reasons, have not been getting all the money we should be getting. And we've worked hard with the Law Society, and we're grateful for the support of the Law Society in revamping the forms this year, which we're hopeful will enhance our income going forward. We await the report from the Law Society, from Library Co. on law libraries. We're, of course, keenly interested in that, too, as an organization that we have been supporting. Just a few weeks ago, we completed a strategic planning session. It was a little bit smaller than the one at Niagara-on-the-Lake, maybe a little more, well, it was no less ambitious, shall I say. And we there reaffirmed our commitment to supporting the organizations that we do support, but also to continue to be innovative and look outward, challenging applicants and grantees to develop new ideas and to show us new ways to have the law reach people and be a force for good in society. That strategic plan will soon be posted transparently on our website. Before closing, I would like to recognize two people's extraordinary contributions over the last several years at the Law Foundation, former bencher Mark Sandler and Elizabeth Goldberg. Mark stepped down as chair a year ago after several years as chair, seeing the foundation through a very difficult and challenging time. He was a superb leader of the foundation, and we're grateful for his steady hand. But even Mark would say he couldn't have done it without Elizabeth Goldberg, who was recruited to the foundation by Larry Bannock, who I know is on the phone today. Larry, of course, was chair in the good times when there was lots of money. He could do anything he wanted just about. But one of Larry's great contributions, I'm sure he'd be happy to hear me say, was hiring Elizabeth Goldberg away from her job as a senior constitutional lawyer at the Ministry of the Attorney General. And Liz stepped down in June after 7 years as CEO, where she did extraordinary work in professionalizing the foundation, bringing in new grants officers, a superb chief financial officer, and also hiring Tanya, who has stepped, I think, seamlessly into Liz's shoes. So, Treasurer, let me end by saying, as I said at the beginning, that one of our objectives at the Law Foundation is to raise awareness of what we do. What we believe is a good news story for the profession. What we hope with a higher profile will enhance our ability to continue to attract funds and to continue to have the profession support the things we do. We need support from all of you in negotiating with banks, in urging plaintiffs' counsel and others in class actions to provide us with Cypre funds. We need your support as ambassadors to tell the world that it's not just the Law Society and TAG, but I would say perhaps more significantly, it's all of the work that the Law Foundation of Ontario does in promoting access to justice, in improving access to justice, in incubating new and innovative ideas and supporting them. So I'm happy to take any questions. Please read our annual report. I hope you will be as impressed with the work of the Law Foundation as we trustees are proud of it. Thank you very much.
Thank you, Mr. Shabas. Any questions? Okay, Mr. Bird.
I'm sure it's just an oversight, but I'm sure there's also interest collected from paralegals.
Yes, of course there is. Sorry, quite right. Yes, that's just an oversight.
Thank you. Any other questions or comments in the room?
The conference is no longer in lecture mode.
Questions or comments from those on the phone? Anyone?
Herb Strasberg, the Law Foundation has done a fabulous job. Well done.
Thank you, Harvey.
Thank you. We agree, Mr. Strasberg. Any other comments? Or
Roger Yaketti, I don't want any praise or anything, but I was chair of the Law Foundation. I just looked at my file in 1995, which is old history to a lot of you.
You're not forgotten, Mr. Yaketti.
thank you, Mr. Yaketti.
Thank you.
Any other questions or comments? Okay, if not, thank you very much, Mr. Shabas. We know you have another obligation.
Thank you.
Thank you for coming, and again, thank you to the Law Foundation staff here. Okay, next. Call upon Dr. Hughes from the Law Commission.
Thank you, Treasurer, and thank you all for the opportunity to speak with you today and to bring you up to date for many of you on what we're doing at the Law Commission. And also, so in some ways this will be a reminder for some of you, but perhaps it'll offer some insights as well for some of you who are less familiar with us. I'm now referring to myself as the outgoing executive director. I actually will be officially finished 8 years as the executive director next Friday, and the incoming, as I'm now saying, executive director, who is quickly starting to take over that role, will follow me and give you some thoughts about where we might be going in the future. So I want first to bring greetings from the chair of our board, Bruce Ellman, who has asked me to do so. He had another commitment this morning and was unable to attend, and trusted us to represent the Law Commission. One of the things I do want to talk about later are is the role of lawyers in what we do, because it is fundamental that at the beginning, I just want to say that we were created in 2007 with the support of the Law Society, as well as the Law Foundation, as Paul Shavers said, the Ministry of the Attorney General, Osgoode Hall Law School, and the other law schools. We have a number of benchers who are or have been involved with the Law Commission to date. First of all, our current appointee, or the Law Society's appointee to our Board of Governors is Raj Anand. We have Avi Go, who is a member of our Community Council. Chris Brett, who was our former Law Society appointee and for many years served us extremely well. We also, Larry Bannock, who is on the telephone, was the former chair. We have met with the Access to Justice and the Aboriginal and Equity Issues committees on a fairly regular basis, and I hope that continues in the future. That's been illuminating for us, and I hope for them. So there are many of the benches in a formal capacity, but as I say, I'll talk in a little while about the role of lawyers as well. So our mandate, as decided in 2007, is to clarify the law, simplify the law, make the recommendations to do so, make recommendations to make the law more efficient, accessible, equitable, relevant, to think about how technology might be able to be used to increase access to justice, to advance scholarly research, and to also, and this is one of my favorites, stimulate critical debate about the law. And we try to do all of that through our projects and through our other activities. So let me just talk a little bit about the projects. They are our major activity. Once the Board of Governors decides about the projects that we'll be undertaking, and we've now completed our 12th final report. The last one was launched November 19th, and that was on a simplified procedure for small estates. We are undertaking at the moment a very big project on capacity and guardianship decision-making for people who need help with decision-making. Huge project. We've just started one on defamation and the internet. We're also doing one on class actions. And we're also undertaking a project which is going to require a great deal of sensitivity and consideration on the last stages of life and improving the last stages of life. And you can see from even the ones we're undertaking now, and there are two in the wings, Redefining Parentage, and looking at questions of community safety and who should be involved formally in helping to promote community safety. Those two will be undertaken as others are finished. We will also be, and we're in the process now, of trying to determine an appropriate project that will focus on Aboriginal issues. This is something that the board is committed to, and we're taking our time to make sure it's the right project. All of those show you, when you think about the kind of projects we undertake, that they're quite a variety. Some of them are relatively narrow legal points. We did one on joint and several liability under the Ontario Business Corporation Act. They may be a complete review of legislation, as we did with the Provincial Offences Act. But we also undertake projects that are broader, multidisciplinary, look at law in context, so social context. Two projects that we did were actually to develop frameworks for the law as regards persons with disabilities and older adults. We did one on vulnerable workers, which looked not only at statutory provisions, but also on what it's like for vulnerable workers who never have a secure job and go into old age, for example, without having a secure job. What is the impact of that? So a lot of different kinds of projects. We also undertake events, and we've had a number of events since we began: Roundtable on Family Law, Roundtable on Joint and Several Liability under the Ontario Business Corporations Act. We co-hosted a major event on older adults, the law in relation to older adults. So that our activities, we try to engage with others. Collaboration is extremely important to us, and I can't go into all the details there, but we do partner with others in our consultations, and that's of enormous assistance to us. Let me talk about quickly the process that we follow with projects, and I'll talk about the role of lawyers in this process. So we receive proposals from anyone who wants to make a proposal, and they come from individuals, they come from academics, they come from institutions, and they come from lawyers. So we have actually undertaken projects from lawyers. For example, the Provincial Offences Act was actually proposed by a practicing lawyer, and there are others. We then appoint, I have assigned that in the past, and I will be doing the same, to one of our research lawyers in-house usually. And that person starts a fairly prolonged process with some preliminary research, some preliminary consultations to get a better sense of what the project should be about. And then creates an advisory group. And I can say that as far as the advisory groups, I think lawyers, practicing lawyers, members of the bar have been involved in our advisory groups in just about every advisory group. And in some, they are major participants. So the recent Small Estates project, for example, was almost entirely made up of practicing estate lawyers, as well as some others. Other advisory groups, depending on the nature of the project, will involve members of communities that are directly affected by the project, the area of law that we're looking at, and as well as others who are clearly affected. That will involve lawyers who are practicing in the area, members of the judiciary. We always have government representatives, and so on, so academics. So our advisory groups do vary, but they're very much reflective of the nature of the project. We do a series of documents, so there is a big discussion paper for feedback. Following that, there'll be enormous consultations, extensive proactive consultations, focus groups, interviews, questionnaires, all different ways of making sure that we do the best we can to hear from everybody who wants to let us know what they think of this area and whose expertise we need. In that regard, we have focus groups with lawyers. The expertise that lawyers bring about the application and implementation and the attempt to use law is crucial to our looking at it, and there are others as well. We receive written submissions, informal emails, any form that you can think of. And again, I think about, for example, our family project. A number of family lawyers sent us emails as well as formal submissions, which we then cited in our family law report. This was really crucial to our dealing with these issues. And subsequently, we release an interim report in most projects, and again, get feedback from that. And that has draft recommendations, so people know what it is, at least at that point, that the Commission is thinking. And then we do a final report. And so the board approves interim reports and final reports. So it's quite a lengthy process. But without the participation of lawyers, I think it would just be an entirely different process, and clearly would not enable us to really look at law in social context. A lot of lawyers are able to help us understand what broader impact law has, and that's important to us as well. So in addition to that kind of participation, we have been very much involved in other activities. I've, for example, attended a lot of equity sessions and educationals that have been put on by the Law Society, which I found extremely helpful. I have attended other kinds of educational events. So that kind of informal and sort of ad hoc relationship. Significantly, the Law Commission was involved with TAG right from the beginning, I think, on the reference group, and Nye will take over that when he formally begins. So we'll continue that relationship. So I think that in that sense, we very much are part of that priority for the Law Society of enhancing access to justice across Ontario. This is, for the Law Commission, something that we have worked through over the last 8 years. We have tried different ways of engaging, and we continue to do so. We're always happy to hear suggestions for engagement and to have invitations like this, because I think that being able to let people know what it is we are doing, what it is we hope to be doing, the importance of the legal profession to that, is one of those collaborations that we've learned over time that every organization that cares about advancing access to justice, and I use that in many ways, whether it's a narrow definition or a broader definition, every organization that wants to do that has to engage with others. And they have to engage with a wide range of others who are involved. One thing I will say, we are one of 6 law commissions in Canada. Some provinces don't have law commissions, and the Federal Law Commission was depleted of funds in 2006, just before we were actually created. And so, you know, we have tried to develop a different way of doing law reform, and I think we've been able to do that from some of the other law commissions. There have been wonderful models internationally, but I think that we have tried to adapt that to Ontario. So I want to thank you again for letting me bring you up to date on what's happening with us at the moment. And more significantly now, if I can let Nye take the podium and talk about the future, which is what you're really interested in.
Thank you. Thank you, Dr. Hughes, and very best wishes. Thank you for your contribution.
Thank you.
First, let me thank you, and let me say for my part that I hope that during my time at the Commission we have a successful relationship, productive, collaborative relationship with the Law Society as we have under Patricia's leadership, and that is a fundamental goal of mine in both the near term and in the long term. And it reiterates the point that we are all in this together. We are all committed to access to justice. We're all committed to improving the justice system in Ontario, and we're all independent yet crucial pieces of a larger system which depends upon collaboration, cooperation, communication. And for my part, as I know it was for Patricia's, this is a fundamental goal. And one of our fundamental priorities in this relationship is to continue to work with the Law Society as an institution, with benchers, with staff, on committees, however it may present itself in that particular situation. So I want to state that as a first principle in terms of our relationship with the Law Society. Patricia went over the process that the Commission has developed over the years in developing its work, and I will say from my experience, I'm new to this, to the Commission. I'm not new to legal policy or public policy. I will say, admittedly, you can take this with a grain of salt because I'm no longer an outsider, I'm now an insider, that the Commission's work is the gold standard of legal policy analysis in this country. The process that has been developed over the years in terms of the legal research, the work with communities, the work with social science research, the work with institutions outside of the justice system is first rate. And it's part of my mandate, I believe, to continue this work and to expand it where we can. There are a couple of sort of short-term initiatives I want to tell you about, then I want to talk a little bit about some of the longer-term stuff that's sort of on the drawing board at this point. It's not crystallized in a plan yet, but these are just some of the ideas that we've been talking about, and I hope to bring forward to the Commission and to others over the next years. First, as Patricia mentioned, we just released a report in this building a couple of weeks ago on small estates. That's an important contribution to that area of law. I commend those of you who are interested in small estates, and those of you who may not be, but who are interested in law reform work generally, to look at that report if you have the opportunity, because I think it's a good example of the kind of work that the Commission does. Secondly, we are releasing a major report, interim report, on capacity and guardianship in early January. I believe the date today is January 12th. This has been a multi-year project looking at these important legal issues that affect individuals, institutions, lawyers, all across the province. And the interim report is the culmination of several years' work, consultation, analysis, collaboration to come up with what we believe to be an important contribution to this issue. We'll be releasing the report and then going back out into the field and asking people for their thoughts, their ideas, their comments, criticisms, compliments on the work that is put down on paper. And we will be touching base with the Law Society and making sure that your members have the opportunity to participate in every way practical on this report. We're also beginning, again, as Patricia noted, we're gearing up a couple of interesting projects. One is on defamation law on the internet. It's a very topical issue, very timely. I can tell you that we've only started to go out and speak to some people. Indeed, we have and will be speaking to some people in this room on this topic in our early kind of development phase. We've already generated a lot of interest across the country and indeed from other parts of the world in this project. So this is a very exciting project for us as well. And then the final project that's in the works right now, sort of in the development phase, is the project that Patricia talked about, end-of-life decision making. Again, this is topical, tough, emotional, tricky, legally complex area that I think will benefit from the Law Commission's independent, multidisciplinary, collaborative, consultative approach to bring hopefully some constructive, thoughtful, principled ideas to the table to move this debate along. In our earlier stages of development, the projects that Patricia talked about, we have a project in public space, community safety. We have a class actions project. Another project that I and some of my colleagues are working on right now is what we're calling simplified policy tools. And this flows out of a couple of major projects that the Commission did a few years ago, developing frameworks for the analysis of persons with disabilities and for older adults. The Commission produced very comprehensive, thoughtful reports that are, quite frankly, they're kind of long. There's an executive summary, but they are complicated, complex pieces of work. We are trying to turn those into more, for lack of a better phrase, kind of more user-friendly. Turn them into tools for policymakers, be they in governments, be they advocates, be they at the community level. Turn these complex pieces of work, these complex frameworks, into tools that can be used by different people across the justice system when they come to make their own decisions as to matters that may affect persons with disabilities or older Ontarians, those sorts of things. We intend to use a variety of techniques to create these tools. We hopefully will have an interactive web tool, we'll have plain English stuff, we'll have a whole menu of strategies and techniques to help turn this complicated piece of work into something that can be used as a practical tool for decision makers, principled tool for decision makers when considering these issues. Those are kind of the projects. I'll tell you a little bit about some of the other kind of blue sky ideas we have right now that I have not confirmed with my new board, but you'll be the first to know. One of the areas that we're all struggling with, and this isn't just the Law Commission, I think it's the Law Society, it's everyone in the justice system, is this idea of what's now fashionably called knowledge mobilization. It used to be called knowledge transfer. a number of different kind of breezy, names for it. What it really is about how to turn good analysis, good reports, good work, thoughtful analysis of issues into tools or turn it into action. The simplified policy tools I was talking about are our first kind of dip into this area. There's a lot of experience in the medical field and the academic field using, again, what are now somewhat fashionably called knowledge mobilization techniques to turn their research into action, either in terms of, in our case, legislative reform at its highest level, or in terms of policy guidance, or in terms of stimulating critical debate, or just informing people in the course of their work about how to think, perhaps in a more thoughtful, principled, contemporary manner about things. So that's going to be an area of interest for us. We're also pursuant to that, independent of that, but this complements the first piece, is we're hoping to develop a new digital platform for our work. Again, I think perhaps like the Law Society, a lot of other organizations in the justice system, I don't think we use our digital tools effectively enough. We can see them in a number of ways. First of all, we can improve them as a means of consultation. One of the benefits of technology is that at the very least it expands your geographic reach. So you can suddenly talk to more people who you might not be able to if you're a small organization based in Toronto. Second part of technology is dissemination. How you get the word out, how you distribute the word, how you engage people in the conversation. My own view of technology is not that it is a replacement for good old-fashioned meetings, good old-fashioned focus groups, talking to people. It is rather an important supplement to those techniques, and we hope to add that to our menu of techniques. Other ideas that are sort of kicking around, we're trying to do a little bit more empirical work. Again, similar to many organizations in the justice system, we're good at the legal analysis. I think we're pretty good at a lot of policy analysis, but we can all benefit from a greater empirical grounding to some of our work. It doesn't come up in every context, obviously, but for some of our projects, which are multidisciplinary, province-wide, complex projects, there's a real benefit to bringing in some more empirical analysis. Again, my view on this is pretty simple. It's a tool, it's a technique, it adds to the conversation. It's not a replacement for any of the normal work that we would do as lawyers or policymakers in the course of our analysis. It adds to our analysis. Finally, sort of longer term down the road, we're in the very early stages of developing a long-term funding strategy. We're in the process of, this is a year, the end of this year, we'll be for a new strategic planning process, so we're in the early stages of working on those ideas as well. All of which, I would be happy to report on, either at TAG or at any other forum to which the Commission is invited. And I would just conclude by saying, again, thank you for the opportunity, and I hope that in the years ahead we have as productive a relationship, in the future as we have had in the past. And thank you. And if there are any questions on your petition, I would be happy to address any of your concerns or questions. Thank you very much.
Any questions, or I should have asked if there's any questions of Dr. Hughes too. Did I see Mr. Gottlieb's hand? Who did I? Hand, I'm sorry, Ms. Go, sorry.
Congratulations, Mr. Thomas.
Could you just go to the end of the podium because of the webcast? Thank you.
Congratulations, and well, I guess you didn't want to say retire, but
Right, I'm avoiding retirement.
Yes. So I certainly look forward to working with you both as a bencher, but also as a member of the Community Advisory Council. And I understand that, so the Law Foundation, Law Commission has done some sort of big sort of piece of work around people with disabilities and elder law in the past. And I understand that you have now kind of moved beyond having those kind of projects and try to address, I guess, more concrete areas of law, as I understand. And not necessarily. So, because I'm just wondering, as you heard our treasurer mentioned earlier, we're still in the process of working on the issues of challenges facing racialized licensees, and certainly the issues of access to justice for members of racialized communities is an ongoing challenge, particularly for this province. Just wondering if you have any thought or any plan on how to advance justice for that particular community, given that in a couple of years' time, 1/3 of the population will be racialized in Ontario. Thank you.
Let me just say one thing about that, AB, because during our call for proposals last time, you in fact did make a proposal in relation to a framework related to racialized groups. And what I can say about that, this is not a statement about what might happen, but I think it's important to understand that it'll be something that I will be talking with the board about and deciding with the board. But the board was concerned that we needed to really see how the two framework projects were working out. Was it possible to use them? We're using them ourselves in relation to the capacity project. That's exactly what will be applied, what is being applied in that. But the fact of the matter is that until I think we see how the simplified policy tools work out and whether it's possible to really apply them effectively, we think it is obviously, but the board wanted to hold off looking at another one. So that is no guarantee there will be one. I think it's fair to say that the Commission has not resiled from looking at this kind of big project. So if you want to...
I think there's a two-part answer to that. One is, how do we account for the perspectives of racialized communities, other communities, First Nation, Métis, and Inuit people? How do we account for Ontario's geographic diversity in any project? And we are committed, Patricia was, I am, I know the board is committed to ensuring that every project we do, no matter what the subject, that perspective is sought out and is included in our analytical work and is part of the process. It's baked into the Commission process, and I think what has been demonstrated in the past is that the Commission has gone out of its way to seek out the perspectives of communities across Ontario. If there's advice about how we can do that better, because you can always improve, let me know, because I'm all ears. And we want to do this well. It's important. So that's in terms of individual projects. And then there's the question of sort of other projects, new projects. We have a full plate right now. At some point, I'm not quite sure when, but hopefully sooner rather than later, we'll be seeking out new projects, and there'll be an opportunity to advance other topics. And I'll say one thing that's on the it's in the middle term. I wouldn't say the long term. The middle term is, I think Patricia alluded to this, is a project respecting First Nations, Métis, and Inuit peoples. We've already had some conversations with staff and a couple of ventures at the law side about what the appropriate scope of this project, appropriate scope, topic, process for this project might be. And we'll be continuing to talk with people over the next couple of months to try to frame something that fits, frame something that complements the law side's Aboriginal initiatives, Legal Aid's Aboriginal initiatives, the Minister's Aboriginal initiatives, something that adds to our collective priority to improve services for First Nation, Métis, Inuit, and Ontarians. I hope that helps.
Thank you. Any other questions or comments? Any questions or comments on the phone?
The conference is no longer in lecture mode.
Questions or comments for either Dr. Hughes or Mr. Thomas? Sorry. Not sure what that indicates, but we'll assume not. Okay, thank you, Dr. Hughes.
If you don't mind, one other point, because I'm feeling a mea culpa is required. One of the values is transparency, so I want to be transparent about an error that I made, and that is indeed that paralegals are involved in our project. As one who came through this process. It's still, I must admit, one has to remember to say what is in fact. And we have had paralegals on advisory groups. We have had paralegals quite involved in that project. So I just wanted to be very clear about that and apologize.
Okay, thank you very much. Okay, well, thank you very much to both of you for coming. We look forward to working with you in future, Mr. Thomas. And again, as I said, best wishes for your next chapter, Dr. Hughes. Okay. We'll move on now to our agenda. Thank you, all guests, for coming. We've got a change in our agenda. On the professional regulation committee report portion, there was a listing of the proposed summary revocation authority for indefinitely suspended licenses. I've been asked to stand that down and to defer it to a later time to permit some further discussion in one particular area. So we will not be addressing that today. We're also going to take the Professional Regulation Committee report next, and that's Mr. Mercer.
The one remaining matter on my report is the Professional Regulation Division quarterly report for the third quarter of 2015. You have before you in board books the division's report starting at page 149. And one of the important jobs of Convocation is to continue to monitor one of our important functions, which is dealing with the regulation of professional conduct principally, but as well other matters that are within PRD. And the reason that I emphasize that, and it'll be obvious to everyone in the room, is that one of the crucial jobs of law societies and ours is to ensure that the public knows that we deal properly, promptly, and transparently with professional conduct matters. One of the things that Convocation does, and you should consider, and I know you do, an important function, is watching whether or not we do this effectively and whether or not the system is working properly. So I say that not to be alarmist, but just to remind you why we report this. There are three principal parts of the quarterly report, four I suppose, but within PRD there are three. There is the intake part of the process, where that which is received from clients, from the public, from elsewhere, are assessed to determine whether or not they are matters within the jurisdiction of our process. And the next stage really goes into one of two places, either complaint resolution or investigation, with complaint resolution by its design being a place where either the less serious matters or the matters capable of being remedied, less likely to be on the ultimate disciplinary track, are dealt with. Investigations are intended to be the more serious matters, more likely to find themselves in discipline. Although I hasten to add, given we have about 150 to 200 hearings a year and about 4,500 complaints a year, it's obvious that a very small portion end up there. What you have in this report is the tracking of the number of matters coming into those three groups, and as well discipline following, as well as the aging within the inventory. And I'm not going to go over in detail this report because it's only one or two convocations ago that I gave you the previous quarter. What I want to do instead, though, is highlight the things in this report that you ought to pay attention to. So the first page that I want to direct your attention to is page 158 of board books, which is page 10 of the report. And you'll see what you have there is a slide from the intake department showing the input over the last 2 years into the intake department. This can be conceived as the what's coming into the system. And you'll see that what's coming in is reasonably stable. Each quarter there are in the range of 11 or 1,200 matters coming into intake to be dealt with. Some of those will not proceed further, others will proceed further. So what I want you to take from this slide is that we have a reasonably stable input into the system. The next slide that I'd like you to consider is at page 164 of Board Books, page 16 of the report, which is in respect of the Complaints Resolution Department. And what you'll see in graph 2.2c is a pattern which showed a couple of years ago a decline from about 1,000 down to about 775 over a year. And since that time, an increase in the department inventory from the low point of the second quarter of 2014 up to the third quarter of 2015. Now, if you only looked at the beginning and if you only looked at the end, you'd say nothing changed. But what you see, I think, is of importance, which is we've got a steady increase going back now a year and a half. You'll see the effect of that in the slide at the bottom of page 16, which showed the median age of active complaints, in other words, how old the complaints were that were still in complaints resolution, being pretty stable from 2 years ago up to a little under a year ago. And you'll see in the last 3 quarters an increase in the average aging of cases in complaints resolution. And so that's a concern. What we're seeing in complaints resolution is not as prompt a resolution of those complaints. Nice when language fits. You can see the effect of that with more detail on the next page. One of the ways of thinking about the age of complaints is by average. The other is to put them in categories or buckets. And you'll see there's a decline in the number of complaints which are under 8 months, down from about 75% down to about 65%, and a commensurate increase in, obviously, the number that are older than that. So that's one data point to note. The other is in investigations, and you should understand that as a parallel department. It's not sequential. At page 169 of Board Books, page 21 of the report, you'll see that the departmental inventory of investigations was relatively stable and flat at just under 1,200 from the third quarter of 2013 to the third quarter of 2014. What you see since then is an increase in departmental inventory. If you look at the median age of complaints at the bottom slide, you'll see what is, again, a healthy long-term trend, but a more recent concerning trend, where the median age is materially higher in the third quarter of 2015 than it has been through the piece. Now, what do we take from that? What we take from that is that we're not processing matters as quickly as we were, and we're not keeping up with the intake. One of the things that I should stop and say, both Paralegal Standing and Professional Regulation looked at this report, both expressed concern about this pattern. And of course, there was discussion with the acting executive director and her staff about this, who brought the issue to our attention. It wasn't something we found, to be clear. And what appears to be part of the history is that the investigation side has called on the assistance of the complaint resolution group for some extra resources. The inevitable effect of that is they've started to get behind in dealing with their work. And what we appear to see is that the investigation side is not processing as quickly as it needs to process. Our job as committees, the 2 committees I've mentioned, is not to get into the weeds of that, not to be the designers of operational solutions, but rather to raise it as a matter of concern, which we have and we do to you, and to say to our very competent staff that these are matters that we're going to watch and be concerned about over time. It may be a resources issue, and I think it may well be. It may be an organizational issue, but one of our key jobs and one of the ways that self-regulation can be challenged, as it has in other jurisdictions, is if we don't watch things like this. And so I come to you not intending to alarm you, but I do come to you intending to concern you. And I hope I've done that without doing the alarming part.
Thank you very much, Mr. Mercer. Any questions or comments for Mr. Mercer from the room? Mr. Lerner.
Before I go to the podium, are you looking at, is your committee responsible for advertising?
Yes.
And I will go to the podium.
We don't do much advertising, but we're responsible for it.
There seems to be an increasing concern amongst the profession with regard to false, misleading, and exaggerated advertising, particularly by some members of the personal injury bar. And I'm wondering what steps are being taken to, first of all, look into that situation, and if it has already been looked into, what steps might be taken or what action might be taken in that regard.
In June, we issued a call for input on a number of issues, including advertising, focused on just exactly that issue. The call for input closed October 15, although there were the inevitable stragglers. And so we have, I think, the final response in at the end of October, perhaps the first day of November. We had a preliminary discussion about that in PRC, so let me back up. The advertising issue can be seen as a standalone issue. The call for input set out particular proposals for changes to the rules that came to Convocation in the spring, and in respect of which comment was received in the call for input. On the other hand, the personal injury issue, and as you've said, advertising is a particular concern in personal injury, raises broader issues of the referral system, what some call a brokerage approach to personal injury, which is tied to the advertising issue, and how it is that personal injury matters come into the legal system and get distributed amongst those in the legal system. PRC considered it was more appropriate to consider the advertising point in that broader context as opposed to dealing with it merely as advertising. And we've asked staff to come back with a proposal to us to the workup or the consideration of the issues you've described.
Thank you.
Mr. Mercer. Any other questions or comments for Mr. Mercer from the room? Okay, Mr. Udell.
To reinforce my colleagues' comments, the same concern has been placed at the feet of the PRC committee with respect to the real estate bar, and we appreciate the work that the Law Society is doing to investigate and see if we can work together with the personal injury bar to try to get some uniformity in that regard. Thank you.
The conference is no longer in lecture mode.
Certainly agree with what has been said. I would say that it's a slightly different issue with respect to advertising. Standing alone, it's a similar issue in that there is concern, I think understandably, within the real estate bar, particularly on the issue of disbursements, that what is described as fixed fee isn't necessarily fully and fairly described, and PRC is concerned about that. The nature of the business model, if I can call that, between real estate and personal injury, do raise quite different issues, as I've described, but certainly there are crossover issues that we need to consider together.
Thank you. Any questions or comments for Mr. Mercer from those on the phone? Hearing none. Thank you very much, Mr.
The
Mercer.
conference is in lecture mode.
I think we'll have one more report before our break. Mr. Brett from Audit and Finance Committee report, please.
That's the problem with having it crowded. I'm okay. Fortunately, that was not on camera, Treasurer.
Oh, yeah?
it to the pulpit.
I've never been a preacher. I've locked those skills, Mr. Falconer. So I'm here to just give you an update on our financial statements. And if I could get you to go to board books at page, now my isn't working here. Let's see what happens.
You broke your phone.
No, that's going to work. Okay. So if you could go to board books at page 220. So what you should have there is a schedule of the revenues and expenses. And what I want to let Convocation know is that we generally have a good news story here. The first thing, is that revenue and expenses that you have there? Is it 220 or 221? 221, sorry. 220. Under revenues, you can see that our fees have largely been in accordance with the budget. Under line 2, you have the professional development and competence. And here you can see we're doing better than budget by about $1.6 million. And this reflects increases both in the licensing process and in the continuing education. Line 3, investment income, you can see that markets are down here, and therefore we're not meeting our budget in terms of what we had estimated. Line 5, other income. Now, other income includes late fees, catering, monitoring, and enforcement revenues. And you can see that there is a favorable balance here. And to some extent, this reflects changes that we made several years ago in order to recover things like late fees and also to better recovery on the monitoring and enforcement. So overall, on the revenue side, we're exceeding budget by about $1.385 million. If you go to the expense side of the equation, line 7 is professional regulation. And you can see that there's a favorable balance here, and it seems to be spread across all departments. Line 8, under professional development and competence, you can see the expenses are well under budget. And I think it's important to understand where we're starting to get some cost savings here. In large part, this is reflecting a move towards electronic materials, webcasts, and that is having a significant effect in terms of reducing expenses. Lines 9, 10, and 11, you can see all are reporting expenditures at less than budget. Line 12, the compensation fund. As you know, there have been 2 major defalcations that are being processed, and this has resulted in the deficits that you can see there. And I think it's important to understand that Convocation has developed policies with respect to these funds. The policy with respect to the compensation fund is that it's to be maintained at a level that would be sufficient to satisfy 4 1-in-100-year event losses. We're now below that level, and because of that, the way the policy works is that when you're below the level, you have 2 to 3 years within which to bring it up within the level. And in our budget for next year, you'll see that there's an increase in the compensation fund levy with a view to bringing it back up within the policy guidelines. So in summary, we had budgeted this year for a deficit, and at this point, it would have been in the amount of $2.9 million. You can see that we're actually recording a surplus this year for the first 9 months of $2.5 million, and overall there's a positive variance of $5.5 million. And we think that it's likely that this surplus will be maintained for the full year. And then just in closing, so overall the results are very good. In terms of the budgeting process, you can see how what a budget is, it's an estimate. So here it's a bit of what you might call Paul Martin budgeting. We were conservative in estimating the revenues, and we're cautious in terms of making sure we budget enough expenses. So overall, what will happen at the end is that if a surplus is recorded, it will go and increase our general fund. And similarly, if we'd run a deficit this year, and in fact, that was, the budget had contemplated a deficit, it would have reduced the general fund. So for people who are wondering about, well, what happens if we have new expenditures and so forth, you can see ultimately it has an effect on the either increasing or decreasing the general fund. So given my spectacular entrance, I know that Mr. Wardle, my co-chair, showing his typical wisdom and timing, left the room in advance of that. So I am available here for questions from anybody who has any questions.
Okay, thank you, Mr. Sorry, let me take a list then if we've got a number, sorry. On this side, I saw Ms. Krieger. Okay, and on this side, Mr. Gottlieb. Okay, anyone else? Ms. Krieger?
Thank you, Treasurer. I'm very happy that we're showing a surplus, and I notice that some of it is arising from savings on CPD. I wondered if we are passing those savings on in terms of lowering the cost of CPD, particularly for soles and smalls, so that they are able to get their CPD hours perhaps a little less expensively.
So what I could say is that at the beginning of each year, the Professional Development and Competence puts together a program on CPD, and as part of that program, they try to estimate what the expenses are going to be, what the attendance is going to be, and so forth. And I think that in effect they try to price it in a way so that ultimately their revenues are going to cover the expenses. So if what happens is that the enrollments exceed what the expectations are, the revenues can be increased. And long run, what we're hoping to do is through these kind of increases is we've been able to keep the cost of fees to the profession as a whole at flat over the past 3 years. So that while you may not be getting a significant decrease in terms of the cost of some of the continuing education programs, those increased revenues have enabled us to keep the fees flat. So that it's not like the revenues are not being applied generally for the benefit of the profession. And I think certainly in terms of the overall program, what my suggestion would be to raise directly with the PD&C, and I think Howard Goldblatt is the chair of that committee, and that's certainly within their bailiwick in terms of how they price the programs and so forth.
Great, thank you.
Thank you.
Pass it on.
Next is Mr. Gottlieb.
Thank you, Treasurer. First of all, my compliments to Mr. Pratt. I know you and your committee do the best you can to keep fees as low as possible and give our members good value for the money they pay. Is it too early for you to make any projections for the future?
Obviously, treasurer, obviously it's a falling market.
Well, I can say that death and taxes are certain, Mr. Gottlieb. With respect to our financial situation, first of all, I think that a huge shout out goes to the senior staff that we have at the Law Society. Wendy Teisel and Fred Grady, and of course our CEO, Rob Lapper. One of the things that when Rob Lapper became the CEO that we had suggested to him is that for a long period of time we've seen a continual growth in the expenses around the Law Society in terms of the number of staff we had around the Law Society and in terms of the fees that have been going up continually. And one of the things that he embarked upon early was an overall operational review. And as a result of that operational review, we have been able to both reduce the expenses, but also see other areas where we can start getting cost recovery. And I'm confident that on a go-forward basis, that the Law Society is in a very strong financial state. And certainly we intend to continue managing the finances in a prudent manner, keeping in mind the core functions that have to be funded regardless.
Thank you. Mr. Byrd?
I'm making reference to page 222 of board books in regards to paralegal revenue. And under the category number 5 of other, it was estimated at about $309,000, but it seems that we've doubled that almost at 216. My questions are, what's attributable to that difference, and what sort of revenues are classified as other?
The types of revenues that fall within that are things like late fees. So what happens is there's an expense that gets caused when people pay their fees late. And so we didn't used to get cost recovery on that. And so now if you pay your fees late, there's a late fee that gets charged. It also includes things like catering. So I think the catering operations have been done better than expected. And I guess a portion of that gets charged to the paralegals. The other thing is monitoring and enforcement. And we used to take very few steps to try and recover fines and stuff with respect to people that have been disciplined. And we're getting better recoveries on that as well. So those are the various different things. The specifics with respect to the paralegals, you know, I suspect a lot of that might be the late fees that maybe some of the paralegals aren't paying on time. We collect a lot from lawyers as well. I mean, I think lawyers are equal opportunity late payers, but that may be an explanation.
Okay. Mr. Faulkner?
Treasurer, I want to echo through you, Mr. Gottlieb's statements concerning the importance and the quality of the stewardship financially. And again, I am very grateful, despite my ribbing of Mr. Brett and Mr. Wardle for their wonderful work. I want to echo the sentiments of my colleague, Ms. Krieger. I'm glad she brought it up, and I can't believe I've been so thick not to really think about it from an equity point of view. There is clearly a differential impact of the requirement of CPD across the profession. And when you consider the haves, such as large institutions, large institutional firms versus the have-nots, I would have thought that this is an issue that we really should grapple in a serious way. We've obviously benefited financially from charging these fees, and I think it should be an imperative that we should create some relief for the have-nots in this area, because we regulate in a fashion that requires them in a mandatory fashion to sign up and pay these funds, which is a good thing. But I really want to echo and repeat, I think we should take this issue seriously, because I think there is an issue of differential impact on what we're requiring out of the profession. And given the wonderful financial health we're in across the board, with the greatest of respect to Mr. Brett, I don't think it's an answer to say the profession as a whole, across the board, over 47,000 of us and more, including paralegals, benefits from this revenue. The truth is the have-nots will continue to be hurt by what is a differential impact of the fees. So I think it's something that should be brought up, and I commend Ms. Krieger for raising the issue.
Thank you, Mr. Faulkner. Are there any further comments or questions in the room?
The conference is no longer in lecture mode.
Any questions or comments from those on the phone?
Treasurer.
Yes, Ms. Potter?
Yeah, I would just like to echo the comments that have been made. As those who have been there for a while know, when we did the small firm and sole task force recommendations, one of the things that was not addressed was the reduction of fees for income earners who were in the majority of that group, who were making under $100,000 a year and many well under $50,000 a year. So I would just like to add my support for having another look at another way of calculating fees that would be less prohibitive for part-time members and those who are earning less than a certain amount of money a year, because I do feel there is a big inequity for those opposed to high-income earners, and you just can't compare the lives and the situations of those two different groups. Thank you.
Thank you, Ms. Potter. Any other questions or comments from those on the phone? Hearing none. Thank you very much, Mr. Brett.
Thank you, Treasurer.
We'll have our morning break now.
I gotta wait.
Careful. Take 15 or 20 minutes. Okay, thank you. Let's move back to our agenda. The next item is from the Equity and Aboriginal Issues Committee, presented by Mr. Faulkner, and that will be on the Human Rights Monitoring Group interventions. I wanted to say at the outset that this week I attended the awards dinner of the Canadian Journalists for Free Expression. And one of the speakers there was Mohammed Fahmy, who, as you know, has just been released from an Egyptian jail. His speech was short but had an impact. He emphasized the significant effect of the international response on issues like his to foreign governments. And I just wanted to bring that back to us as we think about our human rights monitoring interventions. He emphasized again it's the cumulative effect and the diversity of speakers that he believes has an impact. So on that note, Mr. Faulkner.
Thank you, Treasurer. I think that karma is showing itself by virtue of my giving Mr. Brett a hard time. My iPad, of course, won't open now.
And you were one of the early adopters.
That's right, and I dedicate this complete failure on my part to Mr. Brett, who I shouldn't have laughed at so quickly, and I feel bad about now.
There's an app for that.
Treasurer, the report in board books for the Equity and Aboriginal Issues Committee can be found specifically at tab 4, page 63 of board books. At page 64 of board books, it's a review of what we're going to be covering this morning. I shouldn't be too lengthy, Treasurer, but you'll see at page 64 that there's a number of human rights monitoring requests for intervention, 7 in number, I say sadly. Secondly, there's some 4 information items, including paralegal appointment to our equity advisory group, as well as equity and rule of law events that I wanted to bring Convocation up to speed on. Beginning with the sobering work of the Human Rights Monitoring Group, at page 66 of board books, Treasurer, you will see that there are in fact 7 interventions that we are raising for Convocation's consideration. I start by just briefly, I say this, not for the purposes of new ventures, because in my mind they're not new anymore, they're just ventures, but for all of our purposes, to remind all of us about the work of the Human Rights Monitoring Group, and you can see it, and I'm going to be asking you to flip to 275, page 275 of board books, tab 13, just for a moment. You'll see the introduction about the Human Rights Monitoring Group. That the monitoring group is set up with a mandate to basically review information that comes to its attention about human rights violations that target members of the profession and the judiciary here and abroad as a result of the discharge of their legitimate professional duties. We look at these matters and we ask ourselves, does this require a response from the Law Society? And a response is prepared, if appropriate, and approved by Convocation under the leadership of the Treasurer. What we look at, and you'll see this at paragraph 3, page 275 of board books, A number of issues go into the decision about intervening or not. We make a decision about based on certain factors. Specifically, when making a decision, we look at the question around intimidations and threats against individuals. We look at the question of whether there is true interference in the discharge of their duties. And we look at the question of the reliability of the information. Now, at page 275 of board books, you will see reference to a lawyer from Turkey, Mr. Tahir Eltsi. This is particularly sobering, and the reason I had you flip to page 275, and I'm going to make you go back to it in a minute, but this is kind of our work at its worst. If you go back to tab 4.1.7, you will see, members of Convocation, a request to intervene in the case of Mr. Tahir Eltsi around his arrest and investigation. And basically, what we are concerned is an arbitrary arrest by police from Turkey. In the intervening period between when these materials were put together and now, literally in the last week, Mr. Eltsi was killed. He was assassinated. And we deal with this at what I referred to before, page 275, as an add-on. In other words, literally between the time we sought intervention, he was assassinated. And I'm going to go over the circumstances briefly. And it really speaks to the nature of this work and the huge, huge burdens, personal and otherwise, that these individuals that we're trying to support face. At paragraph 5 on page 275, according to reports on November 28th, so we're talking about last week, 2015, lawyer Tahir Eltsi spoke at a news conference at a historic mosque in the old city of Diyarbakir in southeastern Turkey. He was calling for a ceasefire, and he pointed to the terrible damage being done to the historic building, the site of which he was holding the press conference during recent violence in the city. Now, Tahir Eltsi, you'll see this in paragraph 6, was the head of the Diyarbakir Bar Association. He had previously been detained and received death threats after saying that the separatist Kurdistan Workers' Party, which is known as the PKK, should not be regarded as a terrorist organization. Mr. Eltsi was active as a human rights lawyer since the 1990s. He played a critical role in investigating alleged abuses by the Turkish state, but he was also outspoken in his criticism of Kurdish militants. You'll see at paragraph 9 that Mr. Eltsi actually appealed for the return to the peace process between the government and the PKK. In other words, he was trying to create an energy towards a ceasefire and a cessation of violence. With other lawyers, he applied for permission to visit the PKK's imprisoned leader, Mr. Öcalan, in hopes that he would issue an appeal for his followers to stop fighting. The government rejected his application. On October 15th, Mr. Eltsi gave an interview to CNN in which he stated that the PKK should not be described as a terrorist organization. 5 days later, he was arrested and charged with creating terrorist propaganda. Now, as you'll see at the subsequent paragraph 11, there are conflicting reports on who is behind the attack, but suffice to say that while giving that press conference, and it's at the top of the page, Mr. Eltsi was saying before he was shot, while giving the press conference, he said, quote, "We do not want guns, clashes, and operations in this historical area, which has been a cradle to many civilizations." Moments later, Mr. Eltsi was killed with one shot in what Human Rights Watch has called an assassination. His killer has not been identified. 2 police officers were also killed. So you'll see at page 277 of board books, we are asking for Convocation's approval to issue a letter very different than the letter we were looking to ask for not 2 weeks ago concerning his arrest. And it relates to his murder and assassination. I will candidly tell Convocation that in reviewing this, and in being the poor committee member who didn't attend the last meeting, I saw what I think is a missing sentence from this letter, and the committee's going to fix that. We don't know who's responsible for the assassination. And you never know any of these things with any certainty, but often there are sources of information, Treasurer, that assist us in deliberations and give us guidance. In this case, because the assassination happened only days ago, number one, there's a paucity of information. But number two, he was playing the middle in a way, as I've just described, without meaning to demean the facts around these issues, because I'm not by no means an expert in Turkish politics, but suffice to say that it is not clear who's responsible for this, whereas the arrest by the Turkish police, that was very clear. And so there will be sentences adjusting this letter to make clear that it is unknown who was at the heart of the assassination, asking for the Turkish government to conduct a fair and impartial investigation and citing the appropriate United Nations declarations. I've spent some time on this, Treasurer, in terms of Mr. Eltsi's death, because it's a sobering reminder that this is all happening in real time out in the world. Now at tabs 4.1 through 4.6, there are a series of other interventions that I wanted to briefly take you through, and the materials are there for Convocation's review. Beginning at tab 4.1, page 79 of board books, we ask that a letter of intervention be written in respect of a lawyer from Bangladesh, Adler Khan. He was actually the recipient of the International Bar Association's Human Rights Prize. He has suffered in a number of different ways, and most recently on August 2nd, 2015, this is the third paragraph, page 79 of board books, the Media and Public Relations Wing of the Police Headquarters in Dhaka issued a press release affirming that statements made by Odekar and the Bangladesh Human Rights Commission regarding extrajudicial executions, in other words, he was criticizing extrajudicial executions, are synonymous to challenging the rule of law and the judicial system. Mr. Khan is facing serious intimidation and serious threats, and the source of those make clear to anyone with the knowledge about how Bangladesh does business that he's in danger. And so we're suggesting a letter of intervention on his part. Secondly, in respect, and you'll find this at tab 4.1.2, we're asking for a letter of intervention in respect of the death of lawyer Karim Hamdi. This is an individual from Egypt. The letter is directed to the President of the Arab Republic of Egypt in Cairo. Reports indicated that on February 24th, 2015, Karim Hamdi, who had been originally arrested by the police for belonging to a terrorist group and issuing public statements about arbitrary detentions and arbitrary arrests, didn't show up where he was supposed to show up following his arrest. He was due to return to the prosecutor's office for further questioning, and he went missing. His lawyers went to the police station to look for him and discovered that he had died. You'll see the letters of intervention being proposed starting at page 88 of board books. At tab 4.1.3 refers to the arrest and detention of human rights lawyer Mr. Narim Bayev from Astana, Kazakhstan. He's well known for exposing financial fraud carried out by banks in Kazakhstan. He also provides legal advice to those who've been deliberately misinformed by banks. In 2011, he was awarded the Kazakh Freedom Award. It has come to our attention that on 12th of October 2015, he was arrested along with another individual, Mr. Mambatalin, the former head of the Rakhniat Party. Reports indicate that police officers searched his office and home, and that his belongings have been confiscated, and that he was, of course, arrested. According to reports, he's been jailed twice this year for up to 20 days for staging peaceful protests. The Law Society is intervening, again, because he's basically exercising his duties as an advocate. At the next tab, tab 4.1.4, Ms. Mohammadi is a lawyer, a human rights lawyer and an activist from Iran. I don't have to educate Convocation on Iran's history in respect of human rights violations. She's a prominent human rights lawyer and activist,
as well as the Deputy Director and spokesperson for the Defender of Human Rights Center in Iran. The history of her harassment by Iranian authorities has been well documented. In a letter dated February 10th from the Law Society, we had expressed concern about her ongoing harassment. It continues today, and we raise for your consideration page 104 to again address what is being done to her. At tab 4.5, sadly, a further example from the Republic of Maldives, Maldives en français, involves a human rights lawyer, Mahfouz Saeed. In his case on September 4th, 2015, Mr. Saeed was attacked and stabbed in the head by two unidentified men as he was sitting on his motorcycle. He has written blogs which include criticisms of the Maldives judicial system, the increasing crime rate, and the socio-economic situation in the country. He's called for judicial reform. This attack occurred a week after he spoke critically of the current government at a rally for the Maldivian Democratic Party. At tab 4.6 is another sad example of a death. In this case, it's a judge and human rights advocate Abdullah Abdelkadir, and I apologize if my pronunciation is off, from Khartoum, Sudan. He was a judge and human rights defender and a member of the Sudan Human Rights Monitor. He provided legal aid, and you'll find this at page 119 of board books. He provided legal aid to victims of human rights violations, particularly in areas affected by armed conflict, including South Kordofan, Blue Nile, and Darfur. He was active in advocating and supporting fellow human rights defenders in these regions. It has come to our attention that on August 24th, 2015, Mr. Abdelkadir, while visiting his hometown in the South Kordofan state, was shot and killed by members of an armed group. Organizations have expressed concern that he was killed as a result of his legitimate human rights work as a lawyer. So we've spoken of 3 deaths, and the 4 other cases we refer to: arrests, detentions, harassment, and threats of death. In all the circumstances, I can only call this report a sobering one, and I would ask for Convocation support in issuing the intervention notices we propose.
Just for clarification, Mr. Faulkner, the first letter regarding the Turkish death, your amendment does not take out the comments with respect to the arrest, but adds the death with clarification that the cause is unknown.
That's correct, and that's with reference to, I'll remind Convocation, to page 275 of board books, what is now tab 13. And there will be an addition referring to the fact that, given the lack of information at this early stage, we're encouraging an investigation be done, and we appreciate that the cause or the identity of the attackers, the identity of the murderer, is unknown.
Okay, thank you very much. Any questions or comments of Mr. Faulkner in the room?
The conference is no longer in lecture mode.
Any questions or comments from those on the phone?
Giselle, I guess just to express as a newbie, mixed feelings, saddened by what we have in the world, but also proud that we have some wonderful people doing such wonderful work. That's all.
Thank you. Do we need a seconder for the motion? I think you're the mover, Mr. Faulkner?
Yes.
Okay, let's see. Over
Mr.
there.
Gobelak?
Oh, all right. Number of seconders, okay. Thank you. Okay, all in favor? Any opposed? Any opposed on the phone?
Heartily in favor.
Okay, thank you. Okay, motion carried.
The conference is in lecture mode.
The Paralegal Standing Committee report, which is next, is for, oh, I'm sorry, I interrupted. You were going to speak about the programs. I apologize.
No problem.
Apologize, go
Treasurer,
ahead.
just at page 138 and on of board books, tab 4.2.3, so page 138, tab 4.2.3, our number of equity events. I just wanted to call on behalf of the Equity and Aboriginal Issues Committee and our staff department to 4 events happening between January and March. February of 2016 is Black History Month, and on February 9th, there will be an event held in partnership with CABLE, the Canadian Association of Black Lawyers. In March, there will be there will be 3 events in March. International Women's Day, March 8th, 2016. It's set out at page 138. Page 139, Journée Internationale de la Francophone, is at the top of page 139. It will be held March 22nd. The last event, and it's not a March event, is January 26th. The Human Rights Monitoring Group is going to be holding an event in honor of Day of the Endangered Lawyer. Now, I didn't know there was an international day called Day of the Endangered Lawyer, but I guess it kind of makes sense as we do this review today, doesn't it? So January 26th is that day, and that was the 4th event I wanted to draw to your attention. Thank you, Treasurer.
Thank you very much. The next item on the agenda is the Paralegal Standing Committee report. It's not necessary to have anyone speak to that. It's there for your information. The next then will be the Priority Planning Committee report from Ms. Hartman. Sorry, I just called on you, Ms. Hartman. Is that satisfactory?
Yes.
Okay, thank you.
Thank you, Treasurer, and good morning, benchers. As you know, at our recent planning session, we approved strategic priorities for the 2015-2019 bencher term. These priorities are built on the Law Society's mandate and governance principles. It is a robust and ambitious plan that reflects the priorities of the new bench, as well as the evolving legal landscape. Now, last convocation, I informed you we would be presenting today a more detailed report of the plan and initiatives for 2016. And this report can be found at tab 9 of your board books. I will take a few minutes to summarize the work that will be undertaken within each priority area over the next year. Our priorities can be captured under 5 themes. One theme is to lead as professional regulator and enhance regulatory effectiveness in the public interest. We will review our regulatory processes and procedures and look at areas for potential improvement with emphasis on mental health initiatives and equity-based principles. Initial work for 2016 will include examining better ways to address capacity issues that may arise in the context of a conduct hearing. We will also consider the development of a regulatory tool to assist in identifying indicators of particular risk in practice and the supports and resources that may proactively mitigate against these. Second theme is to prioritize lifelong competence for lawyers and paralegals. We will continue the important work of the Mentoring and Advisory Services Task Force and look at additional ways to improve and augment practice support for licensees. We will consider enhancements to entry-level standards to ensure newly qualified lawyers and paralegals are competent to provide legal services as they enter an increasingly challenging professional environment. Now, this may include exploring whether skills testing should be considered. Further enhancements to the paralegal licensing platform will be studied, including the potential of additional educational requirements. As the licensing platform evolves, we will also continue with our commitment to explore the expansion of paralegal areas of practice. Third, to enhance access to justice for Ontarians. We will focus on developing a more defined access to justice action plan and on increasing collaboration with justice partners and other stakeholders. Work on this priority will involve a review and identification of activities that can be undertaken by the Law Society to improve access to justice, with a priority given to family law. We will also explore ways to increase the reach of the Law Society's communications with more effective use of new technologies and integrate access to justice into communication planning. Fourth, to engage stakeholders and the public with responsive communications, we will review our existing practices and consult broadly to build a comprehensive communications infrastructure, including how to frame key messages and improve how the Law Society communicates on time-sensitive or emerging issues. We will focus on enhancing public communications to build awareness of the Law Society and improve communication with lawyers and paralegals through greater accountability, transparency, and collaboration. Ultimately, this work will result in a proposal for a multi-year communication plan, which identifies resources and measures for evaluating effectiveness. Fifth, to increase organizational effectiveness, we will focus on expanding metrics and analysis and reviewing and revising our policy process and governance structure, including a program review to assess why a program exists, what it costs, and how it serves the public interest. We will review our policy development process, guided by the duty to protect the public interest, and undertake a comprehensive review of the Law Society's governance structure with the aim of achieving greater transparency, inclusiveness, cost-effectiveness, and efficiency of convocation as a governing board. These are just highlights of the tasks that we have set for ourselves for 2016 and beyond. While many of the activities continue or build on ongoing work, it is nonetheless a very ambitious plan. The Priority Planning Committee has been working closely with senior management to ensure that we set appropriate benchmarks and timelines. The committee will monitor the status of these initiatives and keep Convocation informed. As progress is made, you will also hear from individual committees and task forces. Before I conclude, I would like to draw your attention to the document at tab 9.1. You also have this document reproduced before you. We have produced a graphic summary to clearly present our priorities to members, the public, and other stakeholders. This will be part of our communication plan. The priorities have been grouped into 5 themes, 5 areas of engagement, if you will, and they directly reflect all of our approved priorities with no variation. As you can see, this summary will be available on our website in French and English. And again, it is grouped into our themes: prioriser la compétence continue des avocats et des parajuristes, améliorer l'accès à la justice en Ontario, mobiliser les intervenants et le public grâce à une communication dynamique, augmenter l'efficacité de l'organisation, diriger à titre d'ordre professionnel. So, with our priorities now set for the 2015-2019 term, benchers and their various committees and other groups will now work with our staff to begin to develop each of the approved priorities and to establish work plans. These work plans will include timelines, measures, and cost projections for implementation and follow-through. Benchers, we definitely have our work cut out for us, but I trust that we are all eager to move forward. Treasurer, that completes the report from PPC, and I know that you are definitely eager to answer any questions.
Thank you, Ms. Hartman. Any questions or comments from the room?
The conference is no longer in lecture mode.
Any questions or comments from those on the phone?
Ms. Vesper?
I was just wondering, is in lecture mode.
Each iteration of the strategic plan has
become somewhat more generalized, and this one is the most general in its language, I think. Is it possible for us to get a more particularized version that's broken down by committees? If it was committee chairs that were working on this primarily, it would be useful for those of us who are expecting to have excess time over the next month or so to be able to turn our minds to what is particular to the committees that we're on, and be able to focus in on specifics in that general listing. Okay, thank you.
So, Ms. Hartman, I know there was a more detailed sort of review. Each thing is going to have to go to the committee for it to develop its own approach, of course. And that's going to, so that will to an extent depend on the committee. I mean, what's going to come to committees by way of timelines, et cetera, would be suggestions. So it would track what we've talked about at the strategic planning session. And this document was really partly inspired by the need to have something easily accessible for the public. As you noted from my schedule, I'm out talking to various groups across the province, and this makes, I think, it helpful for them to understand what we're going to be looking at in future. But I appreciate needing more detail, and I think we can, if we don't have something right at hand, we can certainly provide something. Is there something on board books?
251.
251 on board books is the detailed thing we were looking at when comparing this one to make sure there was everything there. I'm not sure if there's something more that you want or not.
Well, the report, Treasurer, is far more detailed than my comments that I made today, so I do invite everyone to carefully review it. Because, for example, when we spoke, or when I spoke about developing a regulatory tool to assist in identifying indicators of particular risk, this work will be done with the oversight of the Professional Regulation Committee and the Equity and Aboriginal Committee. And again, so I would invite people, and that is clearly earmarked in the report.
If there's something else that you would appreciate, very happy to try and provide that.
Thank you, Treasurer. I was looking for something broken down with sort of a list of the priorities for each committee, but I can sort it out from the information that's there if there isn't already something that would be easily handed out. Thank you.
Okay. And Mr. Lapper, did you?
I was going to deal with this in my report, but we will actually be bringing to each committee a detailed breakdown of the initiatives for which that committee is responsible, dates and timelines, and we can certainly do a roll-up of that. I'm not sure that it'll happen while you have a lot of spare time over the holidays, but we will certainly do that in preparation for committee meetings in January.
As soon as possible would be appreciated, just so that we can turn our minds to it. Thank you.
And do keep in mind, these are for the next 4 years. So our most immediate priorities, I think, are to try and make progress on the matters which are underway and which we really would like to bring to conclusion. Any further questions or comments from the room?
Great, then let's get to work.
Have to ask the phone. Oh. Anything further from those on the phone?
I think it's open.
The conference is no longer in lecture mode.
Any questions or comments?
The conference is in lecture mode.
Okay, thank you very much, Ms. Hartman.
No longer in lecture mode. The conference is in lecture mode.
Okay, and next, Mr. Goldblatt, the PB&C report and the Action Group on Access to Justice.
Thank you, Treasurer. With respect to the Professional Development and Competence Committee, there is a report found at tab 10, which is page 260 of board books, and essentially it's coming to convocation for information. There's a necessity to fill a vacancy on the Certified Specialist Board created by Doug Marmer's retirement from serving as a lay bencher, and this is an appointment that is made by the Professional Development and Competence Committee and reported to Convocation for information. At its last meeting, the committee agreed to the appointment of Marion Boyd to fill that vacancy, and as I say, Treasurer, this is for the information of Convocation at this moment. So then, having said that, let me move on to tab 11 and speak briefly about the Action Group on Access to Justice. And I just remind Convocation that we heard from Mr. Shabas at the Law Foundation of Ontario, Dr. Hughes, and Mr. Thomas from the Law Commission describing their work and what they see for the future, and everyone spoke about access to justice. As Ms. Hartman has identified, one of the strategic priorities that Convocation has identified is enhancing access to justice across Ontario, and prior speakers have, both this morning earlier, have spoken about TAG, the Action Group on Access to Justice, and we have taken to reporting on a regular basis all of what the TAG group is doing in conjunction with numerous others across the province and on an ongoing basis. And to that end, I just wanted to bring two items to the attention of Convocation. Number one is that there is a new website, theactiongroup.ca, or www.theactiongroup, currently available only in English, but shortly in early 2016 will be French. I invite all benchers to look at that website. It has links, it has updates, it has information with respect to what is being done across the province with TAG, the Action Group, on an ongoing basis. And the second item that I want to bring to Convocation's attention is the diagram, the beautiful artwork that is outside, and people may have some questions about what is it and what is it doing here. And let me just advise Convocation that there was a meeting, it was entitled Libraries and Justice, Innovative Access for Rural and Remote Communities, and brought together approximately 75 participants from small communities to talk about innovative ways for libraries and justice organizations to work together to access legal information and provide that information to people living outside the large urban areas. And it was divided essentially into, as I understand it, and I wasn't there, but as I am advised and as the information that is available to Convocation relates, divided into two parts. The morning was an inspiration part, and the afternoon was an action part, where the participants decided to get together and develop an action plan. And while that was going on, there was a graphic recorder that was preparing, as the discussion was progressing, a graphic depiction of what was being discussed, agreed upon, planned, and looked for the future, and the result of that is found outside. So what you see outside of this room is the result of a full afternoon of developmental discussions and incredibly eager, I'm informed, involvement by all those participants. And of course, there are pictures on other websites that I can refer you to that show it progressing. And so it's just another example, and the report at tab 11 are further examples of what TAG is doing, and very much look forward to the TAG initiative continuing, developing, and expanding, and merging with the strategic priority that Convocation has adopted on improving access to justice. Thank you, Treasurer. If there are any questions, I'll be happy to take them.
Any questions or comments for Mr. Goldblatt from the room?
The conference is no longer in lecture mode.
Any questions or comments from those on the phone?
Great. Thank you very much.
If not, thank you, Mr. Goldblatt.
The conference is in lecture mode.
Next, Mr. Earnshaw, Compliance-Based Entity Regulation Task Force.
Thank you, Treasurer. The report of the Compliance-Based Entity Regulation Task Force is in your board books at tab 12, and the text begins at page 270.
The report summarizes the task force activities since my previous report to Convocation on October 29th. The task force has been working very diligently since then. We met several times during November to continue the information gathering regarding other Canadian law societies and to draft a consultation paper. I'll say a little bit more about that paper in a few moments. When I was standing here on October 29th, I reported that we had on the previous day, October 28th, a visit from the Prairie Law Societies. On November 4th, we had a telephone conference with the BC Law Society. On November 13th, the task force had an extended 3-hour meeting to consider a key decisions document that would inform our drafting of the consultation paper. On November 23rd, we met to consider the first draft of the consultation paper. We had a very vigorous discussion and received a great deal of input from those participating around the table. And then on November 30th, I attended a conference in Winnipeg, which I'll talk to you about in a moment. So some of the issues which the task force is considering, you will find described at paragraph 5 of our report on page 270 of board books, and you'll immediately understand that these were derived directly from paragraph 47 of the Treasurer's report to Convocation in June of this year, by which the task force was created. I would particularly like to draw to your attention paragraph 5D, which indicates that the task force will study, and I quote, the implementation of compliance-based entity regulation by other regulators. So in this regard, I wanted to take an opportunity to update Convocation regarding my attendance at the meeting of other Canadian law societies in Winnipeg on November 30th, Monday of this week. The meeting was hosted by the Prairie Law Societies, which have been collaborating on this initiative and have been working on these issues for several years. In addition to the 3 Prairie Law Societies, attending the conference were British Columbia, Nova Scotia, and Ontario, all of which were participating as observers. But you'll appreciate that all of the law societies in this country that are considering this concept were present in the same room at the same time. With Mr. Hirsch present as our esteemed guest, if I could stray from my prepared remarks for a moment, I'd like to point out that through a scheduling misadventure, this conference was to be conducted in Winnipeg at the same time as the Grey Cup game, which caused me to question the forward planning capabilities of the Prairie Law Societies, but there it is. And as a result, Ms. Drent and I had some difficulty in securing accommodation in Winnipeg. But the considerable influence of the Manitoba Law Society was brought to bear on the subject, and as a result, they secured for us rooms and conference facilities at the Fairfield Inn, a picturesque accommodation located in an industrial wasteland, quite remote from the distractions of Portage and Main in downtown Winnipeg, and thus very conducive to our deliberations. In fact, about the only distractions were from the CN rail yards next door as the shucking engines went by. But coming back to my prepared remarks.
Thank you, Mr. Hirsch.
Quite welcome, Mr. Hirsch. I'm pleased to report, kidding aside, that there is a national consensus amongst Canadian law societies that we should all move forward on these issues collaboratively, and that there should be a consistent national approach. We've used the term harmonization. The issues that are under consideration are similar to the ones that are described in our consultation paper, which currently is being finalized by my task force. I think it's also fair to say that there's considerable interest in the work that's being done by this law society on these issues. The material in board books speaks of our consultation paper, and we had hoped to be able to present it at this convocation,
but in part because of our attendance in Winnipeg and what was discussed there with the other law societies present, and in part because we've had so much engagement from the members of our own task force, the paper is not yet in a form which is appropriate to be discussed in the public forum. Indeed, some of what we heard at that conference altered some components of the draft consultation paper that we had discussed at our meeting prior to the conference. As a result, the task force will be considering a further draft next week, and we will eventually be placing before benchers in a means which has not yet been fully defined our final version of this consultation paper later this month. And so what I'm going to talk about and what our materials in the board books address is the general concepts that will be in the consultation paper, so that when you see it in final form, you'll be at least generally familiar with what we are going to go to the profession and the public with in the consultation phase on which we are about to embark. So that paper, in its introductory section, will explain why the Law Society is studying these issues. It will define key terms, provide background and context, and give an overview of the current regulatory system. Following that introduction, the paper will address a number of aspects of compliance-based entity regulation, specifically certain principles that have been identified and that I'm pleased to say are consistent with those that are being studied in all the other law societies with which we met earlier this week. And these together will form what's called a practice management system. That is the key to a proactive regulatory system. And the term practice management system, as we use it in the consultation paper, refers to a set of principles or elements which will govern professional conduct. The paper will invite comments from respondents on the following possible components of a practice management system. First, practice management, which encompasses the notion of active supervision to ensure competent delivery of legal services. Second, client management, that is, management of client expectations to ensure delivery of quality legal services to the public. 3, file management to ensure efficiency in the handling of client matters. 4th, financial management and sustainability, which includes but is not limited to business plans and budgeting, consistent billing practices, business continuity, and succession planning. 5th, professional management, building competence and capacity and maintaining collegial professional relationships. And then 6 and 7, which move outside categories of what you might call risk into other ethical concepts, are first, equity and diversity and inclusion, which includes accommodation, equality principles, and cultural competence, and 7th and last, access to justice. Of course, you've heard a lot about that from many of the speakers today. Once these principles are established and explained by the consultation paper, we turn to a series of questions which will be posed for the purposes of our consultation. And briefly going over those questions, first, which practices should be covered? And in this regard, I would direct you to paragraph 13B on page 272, which reads as follows. Questions in this section will cover which practice arrangements should be subject to compliance-based regulation. Sole practitioners, small, medium, large firms. This section will provide information on considerations around various categories and will seek input from readers on their views of the scope of this regulatory approach. We'll then move on to another feature of compliance-based entity regulation, and that is reporting responsibilities. There are a variety of issues that will be explained in this part of the paper, but generally, a designated licensee would be given specific responsibilities, including ensuring that the entity is registered and receiving complaints about the entity or an individual practitioner who is associated with that entity. Other issues in this section include registering the entity itself and how this would be done.
Next, we come to a consideration of the range of regulatory responses. The phrase regulatory response refers to a continuum of possible responses by the Law Society. And it's important at this juncture to note that we are moving away from, if not completely abandoning, the dated concepts of prescriptive rules, reactive discipline, and enforcement, and moving towards a range of responses which would include education, support, assistance, and other remedial measures that would not be in the traditional form of regulatory responses from the Law Society. The continuum, however, would, at its extreme, continue to have an enforcement component. Finally, prospective benefits of compliance-based and entity regulation, a section of the consultation paper in which respondents will be offered an opportunity to describe and comment on benefits and challenges that they foresee, as well as any other comments that they might wish to provide. Later this month, as I said, we'll make the final version of the paper available to benchers, and if you have comments, we will request them by a specific date, as we are working to a target to be able to have this consultation paper go out to the profession in January, as soon as possible in January. We want to have an opportunity for respondents to provide their comments and engage in the consultation process by the end of March 31st, 2016. Finally, the report in your board books describes a variety of modes of consultation at paragraphs 15 to 18. I was interested to hear Mr. Thomas speak of what he called digital tools, and to assure benchers that the digital tools that he spoke of that will allow us to engage a geographically wide audience in our consultation phase will be engaged. In addition to that, however, we will write to a number of organizations that form the Treasurer's Liaison Group and others in the province in order to specifically provide the consultation paper and request their written input. We will also have a webcast in order to reach out as far as possible to members of the profession who may wish to learn more about it, and conduct that webcast at a time that will permit them to respond by our March 31st requisition for responses. And then finally, we would be looking forward to receiving feedback. As I have said, we'll encourage everyone to review the paper and provide comments on it, and we are still on target to meet our anticipated requirement to report to Convocation in May of 2016. So that concludes my remarks on the task force. Treasurer, I'm ready to address questions, if any.
Okay, thank you very much. Questions or comments from the room?
The conference is no longer in lecture mode.
Questions or comments from those on the phone? Okay. I'd like to thank you, Vice Chair Gavin McKenzie, and the committee very much for their work on this. We've wanted to move it forward quickly in order to have the appropriate consultation and bring it back to Convocation this spring. And I'm very grateful for all the work that everyone has done. It's been a very conscientious and thoughtful committee. And when the paper comes, it is not, we don't require a vote on it, but it is important that benchers make any comments or even editorial, slight editorial comments as they see fit. But the goal would be to be able to, for the committee to be able to release it early January, as Mr. Earnshaw said. So I thank the committee and benchers for their attention to this issue.
Thank you, Treasurer.
I think Mr. Lapper.
Thank you, Treasurer. One of the benefits of coming late in the meeting is that most of what I actually wanted to say by way of impact has already been said, so I'm hopefully going to be able to shorten this a little bit and let people move on. My CEO's report appears at tab 6 in your materials, and I'd invite you to read it in full. I'm not going to read it to you, but I would like to highlight a few things coming out of that. And my intention is to do a sort of public version of this, focusing on what's in the materials, and then to break and then go in camera. And I would like to address at that point Convocation about a few things that relate to in-camera matters. So starting out with our strategic planning update, and Ms. Vespri anticipated my first point, which was that we are going to actually move the strategic plan work initiatives into committees now and develop work plans with committees for the strategic planning, and to integrate that into the priorities on which committees are already working. I think it's a very good idea that we would then do a roll-up of that at some point so we can look at it committee by committee, but we'll do that as we develop this. So we're certainly working through to support the strategies developed. Clearly, any further decisions taken by Convocation to either increase the timeliness of completion or redirect the scope of an initiative, resulting in further expenditures, will be supported by appropriate impact statements and reports vetted by committees, the Audit and Finance Committee, and then Convocation for final decisions on funding. Mr. Brett stole my thunder on the finance side of things. However, I did want to address one sort of side issue, if I can go off script slightly, and that is the media reporting on our budget, because there has been a bit of an effort by some media to pick up on certain things that quite legitimately were stated in the fine print of our budget, one of which was that and we certainly said this, that if we didn't carefully pay attention to how we manage our priorities and while we were keeping fees stable, there could be a fee shock in out years when we suddenly had a bunch of priorities that we wanted to do and hadn't kind of worked our way gradually to funding that. Now, that's not my anticipation of how we work around here, and that's not my anticipation of what will happen, but yes, that was in there. All of the good news about how well we have managed seems to have escaped some of the media, but the words fee shock didn't. And so we got a little bit of press about the fee shock that was coming up. They did, however, they were very good. The Law Times, which was the most significant instrument of this, then invited us to comment on that. And I used to be a deputy minister, and in that life I was always told, stay out of the media, a good bureaucrat stays out of the media, right? And so that was in my head, but unfortunately I was sort of the point person on this, so I did give an interview. And they reported it very, very accurately. To their credit, they reported it very, very accurately. Their cartoon is a little less accurate, but the report itself is great. However, on the front page of the paper copy of the Law Times is my picture with the headline, "Catastrophic Injury. Insurer Must Pay Special Award." So I hark back to the advice to stay out of the media, but more importantly, I'm a little worried because not one person today has asked me how I am. And I attribute that to either the fact that nobody cares, or nobody's seen it, or they still think that that's a headline about our budget. In any case, it's going to be corrected, but I don't really care. The only damage done was that my wife was busy looking at the designated beneficiaries under our insurance policy. And I assured her it was an error, and I can assure you that I have not suffered a catastrophic injury, and even managed to make it to the podium in one piece. Unlike my Kilimanjaro climbing partner. Did want to also say, though, that we've been doing a lot of work on PricewaterhouseCoopers, who are our new auditors. The change in auditors takes a lot of work for staff, because you're starting fresh with people that haven't necessarily bought into the perspectives that we have for audit and need to be brought up to speed. So really commend our finance committee for a lot of hard work moving from Deloitte to Pricewaterhouse. All of our required tax returns have been filed, and as reported to Convocation in September, LawPro's request to the Canada Revenue Agency to reassess LawPro as being exempt from tax as the subsidiary of a public body performing the function of government was denied by the CRA. The matter is now going to proceed to tax court as part of what is expected to be a long process. Mr. Mercer helpfully gave you a lot of what I might have given you on the complaints and investigation side of things. I do want to say that we are paying very close attention to some of the issues that he described, and we're working with Professional Regulation Division to get at some of the issues that are there. Complaints generally fluctuate year to year, but the good news, if there is any in that, is that frankly our complaint numbers, our intake numbers, are actually fairly stable. And when one considers that the numbers, the absolute numbers of our professions are rising, the fact that we have stable complaint numbers is at least suggests that the ratio is good. Now there's obviously many reasons for that, and I'm not speculating one way or the other, but that does seem to be the case. Just out of interest, for 77.7% of our complaints are about lawyers, 11.4% are about paralegals, 2.6% are about lawyer applicants, 4.2% are about paralegal applicants, and 4.1% are none of the above because they're about unauthorized practice. In the number of cases going into investigations is going up, as is the complexity of these, and as I've said before, we are actually going to spend quite a bit of time in the new year looking at how to deal with some of that, of the issues that creates. Over the past 8 years, the Law Society has received new reports of mortgage fraud at an average of between 2 to 5 lawyers every month. In 2014, that went down a little bit, and it's decreased again in 2015. From January to October, the Law Society received reports of lawyers engaged in mortgage fraud at an average of 2.2 per month. So that is going down. It's way too early to say that that's a trend yet, because we have seen this kind of volatility before, but one can be hopeful. In response to a request from my last report, I have included in the written version a summary of decisions in the Ontario Superior Court and Court of Appeal relating to 10 lawyers and 1 paralegal arising out of our discipline matters. All of these matters were initiated by the licensee except for one, in which both the lawyer appealed and the Law Society cross-appealed. I'm not going to review those outcomes in detail, but they are there for you to look at. And before I leave professional regulation, I would like to say, consistent with what the Treasurer said, that we're already starting to work on some priorities, and we have ongoing work on things that we are now looking at as strategic priorities. In 2015 in PRD, we created the position of a capacity program advisor. The advisor works with managers to support the work of the Professional Regulation Division as it relates to licensee health issues and incapacity. The advisor is a registered nurse and was recently licensed as a lawyer. The advisor is experienced in geriatrics and psychiatric issues, including emergency psychiatric intake, and is well placed to assist staff in investigating and, if necessary, prosecuting capacity issues. We're also using the advisor for training, and in mid-November, the Professional Regulation Division held a training day which focused on distinguishing licensee conduct from capacity issues and responding to licensee complaints and complainants with mental health issues. Moving on to licensing, the second offering for lawyer licensing, the second offering of the law practice program commenced at Ryerson University and the University of Ottawa in early September 2015, with a total of 233 candidates registered. Candidates have been, as was the case and as is the case in this program, engaged in a variety of skills training activities, practical assignments, and formal assignments during the 4-month training component. Screening and interviewing for the work placements, which will begin in January, is also well underway. As of early November, and I don't have an update on this, but as of early November, approximately half the candidates were placed. In terms of paralegal licensing, in August 2015, the Law Society held the first administration of the expanded paralegal licensing exam to include substantive competencies in the areas of civil procedure, administrative law, and criminal law, in addition to ethics, professional responsibility, and practice management. Administration of the new exam has gone very, very smoothly. 565 candidates wrote in August, and 344 wrote in October. Last night, the Law Society hosted a very successful paralegal reception to which all of the new candidates were invited, and I think about 139, 140 actually attended. It was very gratifying to see so many benchers in attendance and to hear both our Treasurer and Chief Justice Strathy speak so supportively about paralegals and paralegal training. It was also interesting to me that some of the newly licensed paralegals came up to me, and as I spoke to them about what they had been doing, a couple of them said to me, "Who do we give feedback to about this new exam?" And I thought, oh boy, here it comes. And you have to remember, these are people that had succeeded in the exam. So I said, well, just here's my card, send me the feedback, and I'll make sure that the appropriate people get it. And then I said, by the way, what are you going to say? Both of these people obviously said, we really appreciate the fact that you've upped the game for paralegals. Those exams were really tough for us, they weren't easy, but it actually makes a difference to us that you've raised the standards, and it speaks well of the future of our profession. So I thought, okay, give me that feedback for sure. I will be passing it on, of course. In terms of CPD, we've already had a report on that from Mr. Brett in terms of the fact that we're shifting very significantly toward online learning, with more registrants viewing programs by live webcast or on demand. The CPD department is now offering fewer programs with printed materials as members grow more comfortable with electronic program materials. And the department is preparing to move to a standard offering of online materials only, starting in January 2016. This movement obviously, as Mr. Brett indicated, provides savings in program expenses, including catering costs, course materials, and venue rentals. Attendance for CPD program, all formats, in 2015 we estimate to be in the range of 60,000. Want to talk a little bit about legal information and library services, and somebody was talking about there being an app for that. I hope everybody knows that our library services have created a mobile app which was released in September to both the Apple iTunes Store and Google's Play Store for Android phones and tablets. The app enables mobile access to search Law Society CPD articles and the catalog of books from law libraries across the province. Library staff are working with PD&C's communication and marketing team to promote the app. Now, I actually, I don't write this all myself, so this was given to me as part of my report, and I realized I hadn't downloaded the app, so as I was preparing, I did. And I have to tell you, I am absolutely amazed at what you can find with a couple of clicks of your finger. It's just a huge library resource, brings the whole province into that app, and I strongly urge you, even if your specialty isn't legal research, to go on and just see the potential of that instrument for us. For history buffs, the Corporate Records and Archives team digitized and publicized the collection of historic Call to the Bar resources. Organized by decade, the web pages list speakers from the 1930s to the present. In some cases, users can also read the transcripts of the speeches during the Call to the Bar ceremony and the citations presented to honorary Doctor of Law recipients. In terms of communications, our communications and marketing have been building on the Law Society's social media strategy. Again, we're actually moving on some things that we've identified as priorities in our strategic plan, using it more proactively, broadly, and consistently as strategic communications tools to support our corporate priorities. We had a presentation at senior management team the other day about a renewed focus and the development of a very firm strategy on sharing more content and generating social media traffic to our websites, which has already begun to show results. More people than ever follow us on our social media platforms. Our Facebook page now has more than 2,500 likes, more than 6,600 follow us on LinkedIn, and 7,500 follow us on Twitter. And we aim to significantly increase that over the next year. And you can expect to hear more about it from us on that. In terms of media relations, in the past 4.5 months, our team has responded to almost 100 media inquiries. The Treasurer and other Law Society representatives, including once for me, conducted a number of interviews with major Canadian dailies as well as legal trade publications. Interview topics included ABS, compliance and entity-based regulation, Justitia Project, and the Early Careers Roundtable, and Law Society resources for new lawyers. In terms of non-interview coverage, media coverage relating to Trinity Western University was the most prominent, followed by high-profile regulatory matters. We've embarked in 2014 on an aggressive plan to modernize our technology infrastructure, improving both its internal systems and its external-facing presence. The largest project, implementation of an enterprise content management system, revolves around the concept of a single secure location to develop, collaborate, distribute, and archive information internally using Microsoft SharePoint. This will be a technological component of something that's very important to me, which is to reduce the silos that sometimes build up inside an organization and have people seamlessly share information across the organization using this technology platform. Our employees are enjoying a new intranet, now called The Hub, which was also built on that SharePoint platform. So the Hub has helped to integrate the use of SharePoint into employees' everyday activities and encourages user adoption. We're also moving to an automated time and attendance system, and we'll be rolling that out in the early spring. Much work is being done to enhance the user experience of the Law Society portal, including developing a new look and feel that will make the portal easier to use. As I don't know who said this, I believe it was Mr. Chavis indicated that the 2015 LAR and PAR, Lawyer Annual Report and Paralegal Annual Report, will also be the first reporting period where licensees will not have to submit a separate report regarding their trust accounts. Finally, I'm pleased to tell you that the Osgood Hall dining room is going to have its own website. The catering and facilities departments have been working with communications to develop it. In addition to stunning imagery of the Osgood Hall dining room and Osgood Hall, the website will include a daily menu, a link to a reservation app, information on facilities available for rental, as well as catering information. Now I want to tell you a little bit about our most significant resource, which is our people. I'm very pleased to tell you that the amazing efforts of our staff this past year have been recognized in 4 significant awards. Our Continuing Professional Development and Competence Department has won 2. The new e-course format has received 2 awards for professional excellence from the Association of Continuing Legal Education and North American Association of Legal Education Providers. The awards were received in the programming category for the Opening Your Practice simulation game for lawyers and paralegals e-course, and they also received the John Day Memorial Award for professional excellence in the technology category for e-courses. Our Client Service Center achieved Excellence Canada's Progressive Excellence Program Level 4 Award. That's the highest, the gold level of that program. On October 29th, 2015, Terry Knott, along with Client Service Center managers and staff from our Corporate Resource and Training Center, attended the Canada Awards for Excellence ceremony to receive the gold trophy from Excellence Canada, presented by His Excellency, the Governor General. In the spirit of continuous improvement, the larger Corporate Services Division, including the Client Service Center, is now starting a new certification program with Excellence Canada called Excellence, Innovation and Wellness, and I look forward to reporting on their progress. The 4th award, you're going to say that's only 3, whereas the other one I'm going to tell you about in another format. You will also all know that we've undergone a number of moves with the focus on enhancement of workflows and effective workspace. A number of capital projects were carried out to consolidate various departments. Most of you have seen the new tribunal space. Once they were moved out, we created new offices within existing footprints here in the building that achieved efficient space, addressed security concerns, and met current accessibility standards. We moved the Office of the Complaints Resolution Commissioner as well to 393 University Avenue so that their office would maintain some separation from the Law Society. We've moved equity and IT divisions back to Osgood Hall so that they can more effectively coordinate their work with their work partners here. I have to say we're still very tight on space, So we've kind of moved and shuffled things around, but we are at least organized now a little bit more efficiently. With apologies to the policy division, I have not included an extensive report on policy initiatives, mostly because Convocation lives and breathes those in committees and in Convocation, and I did not want to sort of bore you, but they are in my my report. I do want to just give a little shout out to TAG, as the Action Group on Access to Justice continues to evolve as a catalyst for solutions to Ontario's access to justice challenges. There are currently 9 clusters in various states of development, and some of those have already been highlighted today, including the library event, of which the graphic out there is a product. As well, in early October, TAG manager Sabrina Delon gave a joint presentation with Clio Executive Director and 2016 Guthrie Award winner Julie Matthews at the first Innovation in Access to Justice Conference held in Montreal. Their presentation detailed the early collaborative successes from the Family Law Cluster, which has produced an initiative called Steps to Justice. It was very well received, and we congratulate Sabrina and Julie for that initiative. Also want to speak just briefly about our French language initiatives. At the invitation of the National Judicial Institute, José Bouchard and I were provided with an opportunity to present an overview of the Law Society services in French to Ontario French-speaking Superior Court judges. As well, we continue to work with the French Language Services Commissioner in addressing complaints related to French language services, and we are making systemic and proactive change in response to some of the concerns he has raised, but I think this is working actually very well and certainly much better than it has in the past. In terms of the externally facing Law Society, support to members and organizations, we continue to support the Toronto Lawyers Feed the Hungry program. We're providing it significant in-kind support. As most of you will know from an earlier presentation that they've done, they serve approximately 60,000 guests a year at an average annual cost of $360,000. With the current fund balance in the Law Society Foundation, which is the entity that administers the program, and assuming attendance remains at current levels, the program has sufficient funding for 12 to 18 months of operation. That is not good news. That is actually not something about which we can be complacent. We need now to address the long-term sustainability of the Toronto program. That is a serious concern, and we are working with the Law Society Foundation on options to address that. The programs in London, Ottawa, and Windsor continue to raise sufficient funds locally to support the programs in each city. And as I say, we continue to provide very significant in-kind support to all of those. Draw your attention as well to the Member Assistance Plan. As of September, the Homewood Health, the Law Society's Member Assistance Program provider, indicated that we are now up to a 3% utilization rate for our Members Assistance Program, which equates to about 650 cases. 3% is in the range of normal for an organization like ours, but it is in the low range of normal utilization. So we continue to invite you to encourage friends, colleagues, firms to be aware of the program and to utilize it, and for them and their families to utilize it as required. So the counseling cases, within that program, counseling cases represent almost 76% of the caseload. Plan Smart cases, which are their future planning resources, account for about 16%, and peer support counts for about 5.5%. You can see in my report the breakdown within each of those areas. Also want to indicate that with respect to the Law Society referral service, that we have successfully transitioned to a primarily online service with a crisis line and new email address for the public to assist those in need. We continue to need to be out there to inform people about the transition and how to manage this. We have had some issues about people not realizing that there still was some availability by phone in crisis situations, and we're continuing to try to get the word out on that. To continue our support of access to justice, we recently reached out to eligible lawyers and paralegals in unrepresented areas inviting them to join our service for free for the remainder of the year so that we can enhance our capacity in those areas. Parental leave assistance program, number of applicants approved is below projected estimates during the program development. To the end of September 2015, payments for the year totaled about $156,000, which was well below our budget estimate of $300,000. So, with your indulgence, I will say that that is the end of the public portion of my report. If there are any questions, I'm happy to take them now.
Excuse me. Any questions or comments for Mr. Lapper from the room?
The conference is no longer in lecture mode.
Any questions or comments from those on the phone? Okay, thank you very much.
I'd now like to move in camera.
Is in lecture mode.
Senior staff can stay, but
Yes,
we
senior
ask
staff are
others
invited to
to,
stay.
please.
Others,
Yes, and shall we say farewell to those on webcast? Happy holidays, Happy New Year, and we'll be back on again January 28th, I believe. Thank you.
I have a number of things that I would like to